disposed of.
Yes, that should.
I'll pass that order. Give me some time. Let me complete this mention part.
Yes.
Can you not wait, Mr. Purohit, for some time?
I can wait, madam, but I will still argue before your lordship to
No, I'll
give the matter to post.
I will note your submission.
Post petition.
Obviously, it is not that I try to record as many submissions as made by the. No difficulty there.
That will be general submission.
No, you have also fairly referred to the Supreme Court order that we have been discussing.
Yes.
मैंने पेज वन
एक 24-25 फाइल काटी आपण काढी गेल आपण फाइल पर विल टेक इट यस
मैंने पेज वन आइटम 4 नेक्स्ट वीक मिला
नेक्स्ट वीक सब जाक आपण आज करिया कथा ना
सर
नेक्स्ट वीक करछन
सर कंडक्टिंग काउंसिल टिके
जस्ट इट देन you are trying to adjust in a week and you are making it next week. Your name, sir?
Somodatta Sahoo.
You have power here.
Yes.
So S.
Sahoo,
Sahoo for the petitioner. Sir. The matter having been listed for fresh admission today is mentioned by the learned counsel for the petitioner at the beginning of the day's proceeding. Seeking adjournment. Earlier, the matter was heard at length on 26/2/2026. Submissions of the learned counsel for the petitioner were noted and was adjourned by the learned counsel for the petitioner. Stop. Thereafter, the matter was adjourned on 16/3/2026 and 9/4/2026. To grant further opportunity to the petitioner, list in the week commencing
On 3/6.
29/6/2026.
My lord, item number 7 may kindly be adjourned till.
Just a second. आपको ना sir?
Lord,
Our name? Please, your name, sir.
my name is Arnab Mishra.
Okay.
Arnab Mishra.
Mr. Arnab Mishra on behalf of Piranchi Narayan Mahathi for the petitioner. Keep it upon adjournment.
Yes, Lord.
So, a copy on the standing council. Upon a copy, they direction they simple adjournment. Con sir. Have a clear strategy in your mind.
Well, a simple adjournment because
copy will be there.
Copy.
आपको लिस्ट होची प्रेस एडमिशन से नवा को भी चेष्टा करना है. I mean, you should move it actually.
The conducting council.
And that is the reason I am liberal in giving adjournment. Whatever may be the hearing, after hearing, if you are getting adjournment, you should move it. No, I am not compelling you, but I am telling you the context. The matter being in the list for fresh admission is mentioned by the same order. Same order. Aguru or hearing here. To grant further opportunity to the petitioner, list in the week commencing
On 3/6.
after vacation or before Jam.
Well, after vacation.
On 3/6, the copy of the application shall be served on the learned standing counsel. So Amarendra Prasad Ray, who usually appears for the opposite party. It's all kahaku party kori nahanti ko. कौन एक खराब कौन नोटिस देगा इश्यूइंग अथॉरिटी तो पर पार्टी करिवे आपण खाली ईएसआई रजिस्टर्ड ऑफिसर पंचदीप भवन यस ऑफिसर कौन पार्टी करा जाए
Phase 2. 8 to 19.
Item 10 minutes.
तो सुभाष चंद्र पुष्पाला का आइटम 10
Kindly take it after consideration.
10 मिस्टर लेंका
Yes, sir.
तो डीएन लेंका है जी same matter being in the list.
Full coming 6/7.
How second? Or backing na push button. Yeah, same repeat खाली कर चलेगा. Yes.
Yes, item,
डीएन लेंका appearance with
maybe
yes.
item 13,
13.
adjourned after vacation.
13 Ms. Rita Singh for the petitioner. State को पार्टी करछन्ती.
Register civil court.
हाँ से. अपन तो Instagram पे appear करछन्ती हो.
Right.
So अपन ना Mr. Lekha.
My
Mr. PK Mahanti for the OP1. Same listed for fresh submission जोटा election थी. We commence in 6-7.
Item 11, sir.
11.
Item 11, sir. Praying for adjournment, sir.
आपन ना sir.
J.R. Purohit.
Mr. J.R. Purohit for the petitioner. Opposite party blank. Same order. First order टा correction कर लेबे बाकी तापर टाइप करिए ना सब डेटा टाइप करिए.
My lord, item number 18 be taken up today, my lord.
Yes.
Stay.
Yes. We'll be reaching there.
नमस्कार
Yes, madam.
बबीता पटनायक पिटिशनर आइटम नंबर अच्छे 19 आरपीएफएम 264/2025 एक्चुअली ओपी 18 मास हेलाणी इंटरव्यू पैसा दे नांती से जेहेतु ए मास रे रिटायर्ड करि जिवे ए मास से रिटायर्ड करि जिवे
नहीं आपण मैडम आपण एक्चुअली आर यू स्टूडेंट ऑफ लॉ आपण ओडिया ना इंग्लिश कोन बुझचंती
ओडी
ठीक अछि आपण स्टूडेंट ऑफ लॉ बुझ परचंती आई एम ए स्टूडेंट ऑफ लॉ आई कैन कॉन्फिडेंटली से दैट ये जो सब्जेक्ट मैटर टा एक्चुअली इट इज ए लीगली नुआंस मैटर लीगली नुआंस माने बहुत उडे दिग आईनगत दिग बहुत उडे अछि आपण जेटा निजे आर्गुमेंट इति तो कोझा कहले पूरा ठीक कहउछन मो बुझिले आपण कोन कहउछन सेही पाई आपण साथ जदि मो आलोचना करिबा आपण बुझी परिबेनी सेही पाई आपण पचारछि मु जोटे आई एम ए स्टूडेंट ऑफ लॉ मु जेतु आईन रो छात्र आपण जदि आईन रो छात्री हेतिबे ताले बुझी परिबे नहले मते बुझिबा कष्ट हो आपण इथिरे आपण फेवर रे जो गोटे ऑर्डर हिची से जो ऑर्डर टा हिची सेटा कोन इथिरे स्टे हिची हाई कोर्ट रे
नहीं से फैमिली कोर्ट ता एक्चुअली से कमे देइछंती मोर मेंटेनेंस 30 गोटा हेतला एटा एक्चुअली नेट सैलरी को न करी से नेट सैलरी को सरफेस कर देइछंती से जानि कि तांको जीपीएफ रे अधिक काटी देइछंती सेथमे सेटा मोर कमी जाइछि ता एग्नेस्ट तो एटा हाई कोर्ट फाइल हेतला
आपण पढेबा पई फाइल करचंती केते पाउचंती वर्तमान
एबे 18 मास ला किछ पाउनी
हाई कोर्ट स्टे करनांती जदि करी नाहांती आपण जो अमाउंट आपणकर पाइबा कथा सेटा पाइबे सेटा पाइबार बाट हला हाई कोर्ट रे कहले हबनी सेही कोर्ट रे आपण ताकू कुआ जे एग्जीक्यूशन फाइल को आपणकर 125 रे दिया हैछि 25 धारा रे ना को धारा रे पाछन तो सेटा मु देखु छि रोज 100 just one second let me get the file I'm not got the
19.
okay. The family court Noyagada
आगे
आपणकर नयागढ़ कोर्ट ऑर्डर टा हेछि आपणकर केते एप्लीकेशन प्रथमे थिला केते देथिला
आगुरु थिलो 30,000 टका
30,000 तापर सेटा को कमे की कले
16,500 हेबे
16,500 कले
एटा से ग्रॉस रू पड़ देइछंती
से केस तो पड़ी छिबो आपण टिके बसंतु केस पड़ी जो पड़ी
My lord, item 15 of the list, today's list, for withdraw, my lord.
मेमोटा अच्छी रेकॉर्ड रे
Memo record रे अछि,
ठीक अछि मिस्टर एस सतपति
my lord.
स्टेट किया छन यस
Published.
यस सामंतरे
Item 22.
S3, 22, 26.
Item 22. This may be taken up some any other day, my lord. I have some difficulties to do.
22
22.
अदर साइड नाहंती
My lord, नाहंती first time से appear करछन देथि.
तो सिरा पर रीच कर तो आपण अपेयर करछन
No.
22
No.
तो जेटा तो ऑर्डर करिया पड़े
टिके सेकंड हाफ रे मु मोर असुविधा
ठीक
अछि.
और का कहि देई थांतु कदि ना सेक्शन तो अदर साइड अर्जन करबाटा
आगे.
ऑर्डर्स पैटर्न ता
आगे.
कौन क्वेश्चन देखियो but noted, your mention is noted.
Well, in my absence, my lord, I will not be.
No, I'll record your service. Why should I? Yes.
Item 20, my lord.
Yes.
I have taken consent. It was taken up after vacation in the
On the
mean.
same.
Yes, ma'am.
Mr. Acharya.
Again,
I have taken
After vacation, Mr. Acharya.
after. No. In the meantime, I
already in the meantime, he is not paying any single pie to the opposite
That's
party.
right.
So,
Staying for single.
ସେଇଟା ଟିକେ ଲେଖିଦେଇଥିବ
So, party, we are also responsible.
ଆଉ ଲିମିଟେସନ ର ମୁଁ ତାର ଅବଜେକ୍ସନ ଟା ବି ଦେଇଦେଇଛି ଆଇ କପି ଅଲରେଡି ସର୍ଟ
ଆଚ୍ଛା ଠିକ ଅଛି ଆପଣ କିଛି ପଇସା ଦଉନାହାନ୍ତି
ନାଇଁ ପରା
No, my lord, my lord. I have received through the.
1500 ଟଙ୍କା ହେଇଛି ଦିଟା ପିଲା ମା
I have received the file through the lawyer. I could not make contact with the concerned lawyer, so that it will
ତ ପଇସା ଦେବେନି ଆପଣ ଯୋଉଟା ପଇସା ଯିଏ ଦଉନାହାନ୍ତି ମନା କରିଦିଅ
no, my lord, it taken up after vacation, so that in the meantime.
ଏକ୍ସନ ଭିତରେ ପଇସା ଦିଅନ୍ତୁ
Yes, ma'am.
ହେଲା that order will be there ଠିକ ଅଛି କେବେ ଡେଟ୍ କରୁଛନ୍ତି
We council.
ଫାଷ୍ଟ ୱିକ୍ ରେ କରିଦିଅନ୍ତୁ ଓପନିଂ ର ଫାଷ୍ଟ ୱିକ୍ ରେ
ଫାଷ୍ଟ ୱିକ୍ ନୁହଁ ତା ପର ୱିକ୍ ଟା
ଦିଅନ୍ତୁ ସ୍ତ୍ରୀ ଲୋକଟା କିଛି ପାଉନି ବୁଲୁଛି ଧୀରେ
that order I will pass
ଏଇ ଯୋଉ ଅବଜେକ୍ସନ କପିଟା ଦେଇଦେଲେ ଚଳିବ
ଫାଇଲ କରିଦିଅ ଆପଣ ଅବଜେକ୍ସନ ଆଜି ଫାଇଲ କରୁଛନ୍ତି
ଆଜ୍ଞା
କପି ସର୍
ଆଜ୍ଞା କପି ସର୍ ମାଇ
ଠିକ ଅଛି that will be recorded I will pass orders that you will deposit the money yes
Item 26, Lordship. Item
26.
26, Lordship. In this case, Lordship, Mr. Dulhava Ranjan Mishra is no more, Lordship. So my power is there, Lordship. Escape Pradhan.
the person is there
Lordship. So I have no file letter, Lordship. Let me allow that file.
you will contact the client
Lordship.
okay I'll pass that order
After the second.
କେବେ petition ଆସିବ
We council, monthly.
yes 27 to 40 ठीक है item 1 24 and 25 एक 24 25 फाइल उड़ा कौन करना
Three of the order medicine.
3 and 4.
एक order टा लिखूंतो Mr. Sisir Kumar Purohit for the petitioner Mr. T.N. Lenka for the opposite parties T.N. Lenka AGA for the opposite party the writ application has been listed with the office note that the order dated 29/1/2026 passed by the learned the Honorable Apex Court in civil appeal number 9828 of 2024 is placed for reference marked at flag A. Hello. Perusal the perusal of the order of the Honorable Apex Court indicates that the order has been passed in a batch of civil appeals. That is number 9828 of 2024. The Gaudi lecture and a number of cases and dash number of appeals. It would be up to reproduce to quote the order of the Honorable Apex Court in the civil appeal. Para 2, 3, 4, 5. The website to be paste for the party. It is submitted by the Learned Counsel for the petitioner that the Learned Counsel for the petitioner refers to the prayer made in the writ application which is reproduced herein. Stop.
Time till 29th April is there.
Problem ହେଲା sir ଯଦି ଏଟା ତା ଦେହରେ ନଥିବ 29th April ଟା ଆଜି applicable ହବ ଯୋଉଟା Mr. Paul. Whether the civil appeal is part of because this is pending. ବୁଝିପାରିଲେ ଯୋଉଗୁଡାକ disposal ହେଇଛି ସେଟା challenge ହେଇଛି ଏଟା pending ଅଛି. That is the difference.
मैं एटा से बैच में पेंडिंग था या अगेंस्ट दे हैव प्रिफर्ड एसएलपी
ଏତେ ତ order ହିଁ ନାହିଁ କୋଉ order ଟା challenge ହେଇପାରିବ
ମୁଁ ଆପଣଙ୍କୁ ନମ୍ବର ଦେଇଦେବି ମାଗିକି ସୁପ୍ରିମ କୋର୍ଟ
ଏଇ order against ରେ ନୁହଁ actually.
এই order against they had gone to Supreme
11/12/2017
5 appeals were filed 125
এই order টা ଆଜ୍ଞା ଏଠି ତ order ହିଁ ନାହିଁ ଆଜ୍ଞା ଏଟା ଗୋଟେ ରିମାଣ୍ଡ ତ ହେଇକି ଆସିନି
No.
No. There is no order as such. ଆପଣଙ୍କର ଏଥିରେ ଅଛି but anyway there is no difficulty there even if ମୁଁ ଜାଣିନି ଆପଣ କେମିତି କହୁଛନ୍ତି ଏଟା ଚ୍ୟାଲେଞ୍ଜ ହେଇଥିଲା ବୋଲି but ଏଠି ତ କିଛି order ହିଁ ନାହିଁ
ମୁଁ order ଦେଖେଇ ଦେଇ ପାରିବି listing ଟା ଦେଖେଇ ଦେଇ ପାରିବି ତା
ନା ନା ଲିଷ୍ଟିଂ ଦେଖିବା ପାଇଁ ମୁଁ ଆପଣଙ୍କୁ କହୁଛି ମୁଁ ନିଜେ କାଢିଦେବି
Sir.
ମୁଁ ପଚାରୁଛି ଆପଣଙ୍କର ଏଥିରେ ଯୋଉ ରିଟ୍ ପିଟିସନରେ କିଛି ଅର୍ଡର ହେଇନି ସେଟା ସୁପ୍ରିମ କୋର୍ଟରେ କେମିତି ଚ୍ୟାଲେଞ୍ଜ ହେଲା ଦ୍ୟାଟ୍ ଇଜ ଅ ଫଣ୍ଡାମେଣ୍ଟାଲ କ୍ୱେଶ୍ଚନ
ଗଭର୍ନମେଣ୍ଟ
Then ଆପଣ ପଚାରି discuss ନେଇଯାଉ
ଗଭର୍ନମେଣ୍ଟ ଚ୍ୟାଲେଞ୍ଜ କରି
ଏଇଟା ତ ନା ନା ସାର୍ ଏଇଟା ତ ପେଣ୍ଡିଂ ରିଟ୍ ପିଟିସନ ଟା ପେଣ୍ଡିଂ ରିଟ୍ ପିଟିସନ ଟା କେମିତି
ସବୁ ଆସିଥିଲା କୋଉଥିରେ ଅର୍ଡର ପାସ୍ ହେଇଛି କୋଉଥିରେ ନାହିଁ anyway all the
ତେଣୁ ସେଇଟା ହେଇଛି କଥା ସାର୍ ଦ୍ୟାଟ୍ ଇଜ ଏ ପସିବିଲିଟି
batch
that is a possibility.
ଗୋଟେ batch ସବୁ ଅର୍ଡର ହେଇଯାଇଛି
ହଁ ଏଇଟା ପେଣ୍ଡିଂ ଅଛି ଏଟାକୁ ମୁଁ କେମିତି ହାଉ କ୍ୟାନ୍ ଆଇ ରେକର୍ଡ ଦ୍ୟାଟ୍ and Manjushree Patnaik has been overruled by Justice Chauhan. That was way back in 2006-7.
ମଞ୍ଜୁଶ୍ରୀ ପଟ୍ଟନାୟକ overruled ନା ପଦେ ଯୋଉ ଜଜମେଣ୍ଟ ସୁଷମା ନା କୋଉ ଜଜମେଣ୍ଟରେ
ସେଠି ସରସ୍ୱତୀ
Manjushree Patnaik has been decided to be a bad law by Hon'Ble Dr. Justice Chauhan.
overruled but
Overruled mane High Court has been overruled by the Supreme Court in that sense. Supreme Court nije order no. That decision is there with me. Because I carry my old notebooks also. Because nowadays you don't get no chance to get no make notes.
not challenging your
Because ସେଇଟା ସେମାନେ ଅବଜରଭେସନ ଗୋଟେ ଦେଇଥିଲେ ତ ହଠାତ୍ ନାଟା ମୋର ମନେ ପଡୁନି ଆପଣ ସେଇ ଯୋଉ ଟିକେ ରିଟ୍ ଆପ୍ଲିକେସନ ଟା ଆପଣଙ୍କର ସୁପ୍ରିମ କୋର୍ଟ ଅର୍ଡରଟା ଆଉଥରେ ଦେଖନ୍ତୁ
ଆଜ୍ଞା ସାମ୍ନାରେ
I'll ask and just seek your assistance also.
having considered submissions of the party
ନାଇଁ ସିଧା ପାରା ହଁ ସେ ଯୋଉ ସେକେଣ୍ଡ ପାରାରେ ଦେଖନ୍ତୁ ସେ ଅର୍ଡର ଡେଟ୍ ଟା
arranging out of the judgment dated 11/12/2017 passed by the single judge of the High Court directing the director of the education
11/12/2017
17
ଆପଣ ଯୋଉ ଆପଣଙ୍କ ରିଟ୍ ରେ ତାକୁ ରିପୋର୍ଟ ରେଫର କରିଛନ୍ତି କି that I was actually searching.
ନା ଆମେ ସେ ଡେଟ୍ ଟାକୁ ରେଫର କରିଦେବୁ ବଟ୍ ୟା ପରେ ହିଁ
ସେ ଯୋଉ ଅର୍ଡରଟା
ସୁପ୍ରିମ କୋର୍ଟ କହିଲା
ଆପଣ ଏଇଟା ଯୋଉଟା ଆରେଞ୍ଜିଂ ଆଉଟ୍ ଅଫ୍ ଟା କାଢିଲେ ସିଭିଲ ଆପିଲ ନମ୍ବର 9828/2024
ସାର୍ ୟା ପରେ ଆକ୍ଚୁଆଲି ସୁପ୍ରିମ କୋର୍ଟ ତାଙ୍କୁ କହିଲା
ହଁ 9828/2024 ସୁପ୍ରିମ କୋର୍ଟ ରେ କାଢନ୍ତୁ ସେଟା ତାର କଭର ଟାଇଟଲ ପେଜ ଟା କାଢନ୍ତୁ ଆରେଞ୍ଜିଂ ଆଉଟ୍ ଅଫ୍ ପୁରାଟା କାଢିଲେ ଜଣା ପଡିଯିବ ବୋଲେ ଏଠି ଦେଖାନ୍ତୁ ମତେ ଦେଖନ୍ତୁ civil appeal number 9828 2024 24 ଛାଡ଼ିଲେ ଉପରେ କେସ୍ ଇୟର ଛାଡ଼ିକି ତାର ଆସିଲେ ହଁ 24 ହଁ ଠିକ ଅଛି ରୁହନ୍ତୁ ସେଥିରେ ତଳକୁ ଆସନ୍ତୁ ଏତେ ଜୋର ଗଲେ ତ ମୁଁ ପଢିପାରିବିନି ଆପଣ ତ ପଢିବା ପାଇଁ ମୁଁ ତ କହୁଛି ନା ତାକୁ ଜଷ୍ଟ ଆସନ୍ତୁ ଆଉ ଟିକେ ଏଇଟା ଅର୍ଡର ପେଜଟା ଅର୍ଡରଟା ଖୋଲନ୍ତୁ ଖୋଲିଲେ ସେଟା କେସ୍ ତଳକୁ ଆସନ୍ତୁ ତଳକୁ ଆସନ୍ତୁ yes further yes text ଆଉ ତଳକୁ ଏଇଠି ଏଇ ପେଜ ଗୁଡାକ କେମିତି କାଢିବେ ଆଉ ତଳକୁ this book go down ଟିକେ slow so that I can read it okay चलो yes further again out तळକୁ Sure. Just 1 second. To prove. So, that's perfect. Good. Progress. Civil appeal law करते arranging out of court लेकर देना Progress. Yes, sir. Go down. Put लिखा है तो वो arising out of the progress. Progress. So, yes, sir. So, scroll down. Just once. Next. Out progress. Scroll down further. Out 25 पृष्ठ थिला जे 23 ହେଇଗଲା ठीक go back ऑफिस नोट टा देखले क्लिक कले improve go back go down similarities click करें हाँ चलो जो WPC गुड़ाक कारण पड़ो कि तौर स्क्रॉल करूँ देखिए SLP नंबर काले आसी और टी तो लास्ट 33638 of 2018
Yes.
ऊपर को स्क्रॉल करूँ तो सीरियल नंबर 4 जोटा नहीं कि सीरियल नंबर 4 रे क्लिक करो इधर क्लिक करो तो ब्लू डॉट क्लिक हो नहीं अच्छा तो परे देखिए कि यदि रिपीटेशन नंबरटा पाइबे ऊपर देखि दियौ तो which is reproduced area para
May I be permitted to suggest one thing?
yes please is submitted by the learned counsel for the petitioner that the order was an order was challenged order of the honorable single judge was challenged by filing SLP before the Supreme Court, which has been disposed of. Which has been disposed of. As disposed of and is reproduced above. As is reproduced above. Stop. With considered opinion of this court, after the categorical direction of the Honorable Apex Court in SLPs, challenging similar orders that involve similar prayers before this court, no purpose should be solved by keeping the present writ application pending. Stop. The order number or paragraph 4 of the order of the Honorable Apex Court is reiterated in the present writ application. Accordingly, is directed, let decision be taken by the Director of Education, Director of Higher Education in accordance with law within a period of 3 months from today.
Yes, on Tuesday,
Again,
29 January.
ସେଇଟାରେ ନାହିଁ ଏଟା 29 ତାରିଖରେ ତ ସେ ରିମାଣ୍ଡ ହେଇନି ନା
Yes,
अब आपण उपरु गले टी पार्टी डाटा कोन अछि आपण ए जो रीड नंबर रे 25064 रे जोटा आपण पाउछंती 25064 टा जदी चैलेंज हिची कि नै जणा नै आपण 590 टा चैलेंज हिची बुझ परछन हाँ से जदि 590 टा आपण जदि एसएलपी नंबर पाई जिवे सिविल अपील नंबर पाई जिवे ताले कनेक्ट हो आपण जोटा क्वेश्चन सर सेटा तो एक केस रे ऑर्डर हेनी ना हाउ इन ए मैटर पेंडिंग बिफोर हाई कोर्ट सुप्रीम कोर्ट विल डायरेक्ट डिस्पोजल उस क्वेश्चन
Yes.
कौन लिख
ठीक है
let me contemplate actually this is little bit complicated actually for all of us I know because it is not that clear because the Supreme Court has not referred to that any decision order number is there order number ete pass in so and so hitile mil jaithanta so all these efforts of searching out the orders so now we have found about so many SLPs and scroll down click करो इधर I was a counsel of सेटा देखो ठीक है कमन जजमेंट ठीक है तळक असेल तीनटा कमन जजमेंट 590 25064 आ गोटे होची 25432 ऊपर स्क्रॉल डाउन स्क्रॉल अप देखो 24167 that is also referred in the Supreme Court website so तार ऑपरेटिव पोर्शन को जान पूरा तळक पळा तो the state versus Mamata Mohanty. Honorable Justice V.S. Chauhan, Dr. Justice Chauhan, Mamata Mohanty. In fact, this has followed Mamata. Like, today, if not already taken in the meantime, as has been directed by the Honorable Apex Court. Stop. It is submitted by the lauded AG that he has no instruction as on date whether the case of the petitioner has been considered and appropriate decision has been passed by the authority. Stop. The lauded counsel for the petitioner also submits that he cannot for sure say that the petitioner's case has been considered.
Not yet considered. No communication.
Supreme Court order अनुसार है सर.
Supreme Court order अनुसार consider they have not communicated.
But submits that ଆପଣଙ୍କର ଯୋଉଟା ସିଭିଲ ଆପିଲ ଆପଣ ନଥିଲେ କେମିତି କନସିଡର ହବ କଣ ଲେଖିଲେ ନାଇଁ ଚେଞ୍ଜ କରିଦିଅନ୍ତୁ though it is suggested by the learned counsel for the petitioner that the case of the petitioner has also been remanded and should be covered and is covered by the direction of the Honorable Apex Court in order dated एते ହେଲା 29/1/2026 apparently the writ petition filed by the petitioner in 2013 is still pending consideration and disposal. Therefore it is directed to the authority. Seta taparas. What likhi the mudo sajade? Yes. But in absence of the particular details regarding the consideration of the case of the petitioner, it is further clarified that either of the parties shall have liberty to seek further clarification or modification of this order. If so advised. The authorities shall do well. The appointment shall consider within 3 months. সেটা কর্ডিনেশন ঠিক আছে 24 রে আপন স্যার 24 টা খুলিও পড়ে প্রোফাইল বুঝছো 24 রে আপন স্যার পিটিশনার আচ্ছা
Who is petition?
24 रे मिस्टर लेका आपके अछंती 24 25
प्रभु
प्रभु अछ ठीक है प्रभु किछि कहि परछोनी को केस कोन आछि प्रभु भी जानना आमे कोन जानि 24
your
मिस्टर
lordship, all-
पुरोहित फॉर द पिटिशनर मिस्टर प्रभु प्रसन्न बेर एडिशनल स्टैंडिंग काउंसिल फॉर द अपोजिट पार्टी
what I said, sir, all are analogous matter. All the three may be passed in one order, taking note of it.
नहीं गोटे प्रॉब्लम अछि वन ऑर्डर पास कले व्हाट आई एम थिंकिंग सो धरंतु फास्ट किस माने फास्ट मैटर एक नंबर आइटम टा कंसीडर हेछि 3 नंबर कंसीडर हेनी तीनटा कंसीडरेशन रे अछि तो as on date status may be different. Mr. Purohit is confident that no order has been passed. But all matters are kept pending. Jati remand hai ki Supreme Court rasti what Mr. Purohit is saying after remand by the Supreme Court, all cases are considered. I cannot say. Maybe you also do not have that instruction. That is how it is separate orders.
Yes.
तापरे जी चाहिए आसीबे नहले भी तापरे ऑर्डर रे किछि मॉडिफिकेशन दरकार नै द रीजन बीइंग because as on date since this matter is disposed of in the light of the honorable apex court order. एक 24-25 yes the authorities are lacked upon the production of the certified copy of this order. The parties shall also have the liberty to proceed on the basis of the office order obtained from the official website of this court.
One thing may also be taken note of, my lord, that the order of the Honorable High Court has also not been set aside.
The High Court orders are nahi upon case. Upon our further problem that you are not relying upon that order which is considered by the apex court. Just look, when I asked you that the purpose was that suppose the same order is referred in your writ petition, then it becomes much easier. ଆପଣ 11 12 17 जोटा apex court has referred to 11 12 17 order. I have found it out most likely 11 12 17 says by Justice Prasad that in terms of Mamata Mohanty case has to be considered. Okay, that's it. So ଆପଣଙ୍କ case ବି consider ହବ. ଆପଣ ଯଦି only thing is that जे आपणकर ऑलरेडी चैलेंज हेची कोनोसी ऑर्डर बट मोस्ट अनलाइकली आपणकर जदी चैलेंज हेकी आस्थांता हाई कोर्ट रे पूरा कॉपी थांता माने आपणकर बिकॉज़ दिस ऑर्डर दिस आपणकर एथिरे अच्छा त आरंभ देखंतु द आइटम 1 रे द मैटर वाज प्रेजेंटेड बिफोर दिस कोर्ट ऑन 30/4/2013 on 27/2013 defects were directed to be removed by the division bench. Thereafter, upon the determination of the bench having changed, is placed before the single bench, placed before this bench having determination. Yes. So, like anything else?
Yes.
Disposed of.
Not issues.
एक एटा होची 24-25 भीतर प्रॉपर्शन न करती. Yes.
Item 2.
The present division has been
Mr.
filed.
T.K. Mahanti. You are Mr. P.K. Swai.
T.K. Mahanti.
Mr. T.K. Mahanti for the petitioners. Yes.
The present division decision has been filed by the husband allowing an application of the wife for maintenance matter under section 125 of the CRPC matter.
Yes.
The maintenance petition was filed in criminal procedure 155 of 2017.
Yes.
Matter. Prior to this maintenance petition, the present
Have you, sir, one question, because after you spend half an hour, then we get stuck both of us. Have you examined the pleadings and evidence?
my lord, what happened while cancelling?
What happened केमती हो? Pleadings and evidence examine କରିछथि ना नाही?
ଟିକେ ରହିଯାଇଛି এটা ଟିକେ ରହିଛି ମିଷ୍ଟର ଡିପି ମହାନ୍ତି ତ ଆର୍ଗ୍ୟୁ
डीपी मानती पता सर डीपी मानती सर बोलतो आपण बोलतो सर जो भी सर करंतु please refer to the don't instead of making a speech here please straight away go to the pleadings evidence how the court has appreciated so that it becomes effective.
One minute, madam. prior to filing of this.
1 minute रे कौन करिवे 1 minute आपण if you want to say that you will not refer to the pleadings and evidence, say that clearly so that I can pass order.
Once it was filed by the present petitioner, my lord, on the ground of adultery, basing on porn videos of the wife, my lord. These are sold much file hela.
How is it relevant? If a CP is filed on the ground of adultery for looking at pornography, is that a relevant consideration in 125 CRPC? सेटा कोठी सेति पय कहली जे आपण सेटा रिटन स्टेटमेंट रे ऑब्जेक्शन रे कोठी फाइल करछन?
Yes, madam.
हां देखा रिटन स्टेटमेंट देखंतु. कोन पर आगे नाही आगे
Madam.
कोड पिटिशन रे कोठी फाइल करछन?
Madam. The objection, so cause.
Who pays it?
So cause, madam. You can read page 21, paragraph 8, my lord. Paragraph 8, my lord. ଓଡ଼ିଆ ତତ୍ପରବର୍ତ୍ତୀ କାଳରେ 5 କି 15 ନିକଟ ପ୍ରତିପକ୍ଷ ଇଲେକ୍ଟ୍ରୋନିକ ଇଣ୍ଟରନେଟ ମାଧ୍ୟମରେ ଦରଖାସ୍ତକାରୀଙ୍କ ସହ ଜଣେ ଅଚିହ୍ନା
କୋଡା ପଢୁଛନ୍ତି
ପେଜ 21 ପାରାଗ୍ରାଫ 8 ଓଡ଼ିଆରେ
ହଁ ସେଟାକୁ ତ ଲେଖିଲେ ତାକୁ ଆପଣ ଏଭିଡେନ୍ସ କଣ ଦେଲେ
ମାନେ ସେଟା ସିପି ରେ ଏଭିଡେନ୍ସ ଆଲାଉ ହେଇଯାଇଛି
ସିପି ପଢିଲେ ଆପଣ ସିଆରପି ରେ ପଢିଲେନି ସିପି କୁ
ତା ଆଲାଉ ହେଇଯାଇଛି ଡ୍ରାଇଭର
ଆପଣ ଆନାଲୋଗ ସିୟରିଂ ହୋଉଥିଲା
ଡ୍ରାଇଭର ଆଲାଉ ହେଇଯାଇଛି
ଆଲାଉ ହେଇଗଲା ତାପରେ କଣ ହେଲା ସେ
ତାପରେ ବର୍ତ୍ତମାନ ସେ ବର୍ତ୍ତମାନ ଇଣ୍ଟେରି ମେଣ୍ଟେନାନ୍ସ ଯୋଉ ଥିଲା ସେଇଟାକୁ ବର୍ତ୍ତମାନ ଏକ୍ଜିକ୍ୟୁସନ ଫାଇଲ କରୁଛନ୍ତି
ବର୍ତ୍ତମାନ କୋଉ ଧାରାରେ କରିଛନ୍ତି ଆଜ୍ଞା ଆପଣ ଏମତି କହିଲେ କେମିତି ହବ ଲ ପଢୁଛେ ନା କଣ
ଏଟା 125 ମେ
125 ରେ ଆପଣଙ୍କର डिवोर्स ରାଇଟ୍ ପାଇବନି ବୋଲି ଅଛି ଷ୍ଟାଣ୍ଡ କୋର୍ଟ ନେଇଛନ୍ତି ତାକୁ ଯେମିତି ଆଜ୍ଞା ଓକିଲ ଜୁଟିଛନ୍ତି ଟ୍ରାଏଲ କୋର୍ଟ ରେ ସେମିତି ଆଜ୍ଞା ହାଇ କୋର୍ଟ ରେ କହିଲେ ହବନି
ନେକ୍ସଟ ୱିକ୍ ରହୁଛି
ବେସିକ ଫଣ୍ଡାମେଣ୍ଟାଲ ଆଜ୍ଞା ଠିକ ରଖନ୍ତୁ ଆପଣ ଗୋଟେ ସିପି ର ଏଭିଡେନ୍ସ ଆଣିକି ସିଆରପି ରେ ଭର୍ତ୍ତି କଲେ ପ୍ଲିଡିଂସ୍ ନାହିଁ ଏଭିଡେନ୍ସ ନାହିଁ ପ୍ରୁଫ କଲେ ଓଡିଆ ରେ ଫାଇଲ କଲେ जोटा ତାକୁ ପ୍ରୁଫ କଲେ ଟ୍ରାଏଲ କୋର୍ଟ ରେ
ସିପି ରେ ପ୍ରୁଭ
ଫେर କହିଲେ ସିପି ରେ
I mean
କଣ ସିପି ଟା ଫାଇंडिंग ଟା बाइंडिंग सीआरपी रे what you are saying sir you are too sigil
next week
that is how I was telling you that we are simply wasting time
yeah
the court has become only a talking judge
can do lordship take on next week man
can I being a student of law can I do this what you are saying can I dictate this order
no man
which provision have you read first to argue that the divorced wife is not entitled for maintenance वही अनचंदी देखो
yes
कौन yes को प्रोविजन रे अछि
13
आगे
13 of Hindu Act
सर आपण बिल्कुल सीपीआर को जानतुनी आपण टिके 125 रे कंसंट्रेट करंतु
yes ma'am 120 in next week next week my lord
आपण ग्राउंड जो नेले कोन प्रूफ कले
and let the next week Mr. Deputy Mandu will argue
due to death of argue करियो अधिकार
due to death of his uncle his absent man
करियो सर डीपी माजे कोन केस टा को चेंज कर देबे
yes man due to death of his
argue more than you
to death of his uncle today morning his absent
आपण डिवोर्स इचुअली कोठी देखछंदी रिटन स्टेटमेंट रे
এটা subsequent divorce allow it এটা subsequent 2026 ରେ allow it
ଏଇଟା କେବେ ଫାଇଲ ହେଇଥିଲା?
এটা 23 23
କଣ 23 କହୁଛନ୍ତି?
এটা 23 ମସିହାର
17 ମସିହାକୁ 23 କହିଲେଣି। 17
17 ମସିହାର ପିଟିସନ ଟା 23 ରେ
ଆପଣ ଏଭିଡେନ୍ସ ଦେଲେ, ଆପଣ ଏଭିଡେନ୍ସ କୋଉ ଦିନ ଦେଇଥିଲେ? କଣ ଆଜ୍ଞା, କଣ ହ୍ୱାଟ ଇଜ ଗୋଇଂ ଅନ୍ ସାର୍? ଆପଣ 15/12/2017 ଫାଇଲ କଲେ ରିଟନ୍ ଷ୍ଟେଟମେଣ୍ଟ,
ନାଇଁ
ଆଉ 2026 କଣ କହୁଛନ୍ତି?
ସିପିଟା ଅଲଗା।
ସିପି ଆଲାवा ସାର୍ କଣ ସମ୍ପର୍କ ଅଛି ଆଜ୍ଞା? ଆପଣ ଯୋଉଦିନ ରିଟନ୍ ଷ୍ଟେଟମେଣ୍ଟ ଫାଇଲ କଲେ 2017 ରେ ତ ମ୍ୟାରେଜ ଇଜ ସଷ୍ଟେନ୍,
Yes, ma'am.
ମ୍ୟାରେଜ ଇଜ ଷ୍ଟିଲ୍ देयर।
Yes, ma'am. Yes, ma'am.
The learned counsel for the petitioner is had at some length. The petitioner wife, the petitioner husband is before this court, challenging the judgment dated 19/6/2023 passed by the 23 मसीहा judgment challenge କରୁଛନ୍ତି।
My lord.
The judgment dated 2023 passed by the learned judge Family Court Balasore, fast and stay at criminal proceeding number 155 of 2017. The said proceeding was initiated by the wife in the marriage and the minor child born from the wedlock. So, apparently, to challenge the order, the judgment of 19/6/2023, the learned counsel for the petitioner refers to the judgment in another CP, which has been decided in the year 2026. In considered opinion of this court, the judgment pronounced subsequent to the date of the judgment, that is 19/6/2023, would have no relevance to challenge the said judgment in criminal proceeding number 155 of 2017. लिखिले the husband in the marriage जोड़ा लिखिले नहीं challenges से provision टा लिखी दियो तो पढ़ गया होता challenge कौन लिखा? SMT कर दियो तो 6 revision of judgment dated dash 6 revision under section 401 of the CRPC, read with section 19 into bracket 3 of the Family Courts Act. The learned counsel for the petitioner is apprised of the judgment rendered by the Hon'Ble Apex Court in Samima Faruqi versus Sahid Khan, wherein the Hon'Ble Apex Court has authoritatively dealt with the scope of power of revision by this court of orders passed by the Family Court under section 125 CRPC. At paragraph 20 and 21, 19, 20 and 21. This further, the learned counsel is further apprised of the judgment of the Hon'Ble Apex Court in Bernays versus Neha, wherein it is held that it is laid down that the maintenance granted to the wife in proceedings like 125 CRPC is akin to a money decree. The petitioner has to secure to challenge the same before this court. So, the learned counsel for the petitioner has adjournment.
Next week.
The matter shall be listed in the week commencing 18/5/2024. Sir, suppose Mr. Mahanti, you are in a serious thing. You are an officer of the court.
My lord.
Suppose now I would have been impressed and dictated the order. You have not realized that the CRP order is long back. After 2026, what would happen to the earlier order? It will still prevail.
Yes, my lord.
Then item 3,
Item 3,
District person.
what is the prayer?
Mr. Dikranti is absent, he is happy in this matter.
T.K. Mahanti for the petitioner, opposite party black. The petitioners are wife in the marriage and a daughter born from the wedlock. They challenge the daughter, minor daughter. Yeah. Stop. They seek for revision of the order. They seek for revision under section 19 into bracket 4 of the Family Courts Act of order dated 6/2/2026 passed by the learned judge Family Court Kendujar in CRL.P. number 7/2023. Stop. The said CRL.petition was initiated by the mother, by the wife in the marriage and the minor daughter, seeking maintenance under the provisions of section 125 of CRPC into bracket since repealed and substituted by perimeterial provision contained in section 144 of CRPC bracket closed. The present petitioner sought for maintenance at the rate of rupees 20,000 for the wife and rupees 10,500 for the petitioner for the minor daughter. By the judgment, the learned judge Family Court has the learned judge Family Court has directed for payment of rupees 3,000 to each of the petitioners with effect from the date of filing of application, that is 27.09.2023. Stop para. It is submitted by the learned counsel for the petitioner that the quantum of maintenance granted is very less compared to the income of the opposite party husband as father, as was proved before the learned judge Family Court. Stop. Issue notice along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 5 working days. Returnable date be fixed to 30/6/2024 matters shall be listed for admission in the week commencing 6/7/2024 listed for orders listed for orders. This further directed that the petitioner shall continue to receive the amount directed by the learned judge family court by the judgment dated 6/2/2024 without yes 6/2 without prejudice to their rights and contentions in the present application. Yes, next.
Item 5,
The Biswajit Mahapatra for the petitioner, opposite party blank.
My lord,
Yes, please.
I have taken instruction, ICT facility to be available. So petitioner to conduct the case matter in ICT facility. This is a transfer petition. Petitioner is a wife mirror. The transfer of CP will from Kotak to Puri. My lord directed to obtain instruction. So I have already obtained instruction. ICT facilities to conduct the available.
Sir, but that has to be by the rules. There is a ICT rule. Some rule. I not exactly ICT rule, but virtual code so and so rule. So if it is available and possible, they will be allowed. Biswajit Mahapatra for the learned counsel for the petitioner, learned counsel for the petitioner. Then they will repeat Korantu order dated 26/2/2024 para 2, 3, 4, 5. It is submitted by the learned counsel for the petitioner that he has obtained instruction that the petitioner shall move the learned court seeking for availing to appear before the court by utilizing the ICT facility stuff. The ICT paragraph with the above said with the above direction, the petition is disposed of. I hope. Yes. Yes.
And যেତେବେଳେ ফিজিক্যাল আপনি দরকার সাক্ষী
কাউন্সিলিং টা স্যার ফিজিক্যাল দরকার কাউন্সিলিং টা ফিজিক্যাল ন হলে and Puri is a good place ଆପଣଙ୍କର go for the best ଦେଖନ୍ତୁ if they can resume their matrimonial and other
ট্রায়াল বেলাগে ফিজিক্যাল দরকার ট্রায়াল
কেতটা জায়গায় দরকার কেতে জায়গায় সেটা কোর্ট will consider that part I am application দেবে সেটা available থিব এবং রুল অনুসারে সে দেবে তাকে প্রবলেম কোন হচ্ছে আজ্ঞা আইসিটি একচুয়ালি ভিড় হয়ে যাচ্ছে মানে সকাল জন অপেক্ষা কলে সব উপরওଳି কেস পড়ুছে হাইকোর্ট রে যাচ্ছে সম্বলপুরে ধরো তো আই ক্যান গিভ ইউ কংক্রিট এক্সাম্পল তো সেটা বি হচ্ছে আইসিটি হ্যাজ কট অফ দ্য ইমাজিনেশন অলসো কট দ্য ইমাজিনেশন অফ অল লয়ার্স ମାନଙ୍କୁ ডিফিকল্ট ମୁଁ ଏଟା ସାକ୍ଷୀ କଥା କହୁନି ଅଫକୋର୍ସ ଆଇ ଏମ୍ ନଟ୍ ସେଇଂ ଦ୍ୟାଟ୍ କାରଣ ଆମେ ତ ସାକ୍ଷୀ କରୁନୁ
ସାକ୍ଷୀ
ଭାଇ କଣ କି ସେଠି ଆପଣଙ୍କର ରିମୋଟ ଲୋକେସନ ରେ ହବ ସେଇ ଲୋକେସନ ରେ ହବ ଦିଟି ଯାକ ଖାଲି ଥିବ
କଟକ ପୁରୀ କିଛି ପ୍ରୋବ୍ଲେମ ହବନି
ରସ୍ ପ୍ରୋବ୍ଲେମ ମାନେ ରସ୍ ସାର୍ ପ୍ରୋବ୍ଲେମ କନେକ୍ଟିଭିଟି କଥା ମୁଁ କହୁନି ଆପଣଙ୍କ ଆଗରୁ ଯୋଉମାନେ ଥିବେ ଆପଣଙ୍କ କେସ୍ ଥିବ ଧରନ୍ତୁ ଆପଣଙ୍କ ମ୍ୟାଟରଟା ହଉଛି 2025 it will get some priority let us hope ଠିକ ଅଛି yes next please
item 6,
Sir Prakash Chandra Das for the petition.
May I please?
Yes, please.
Last occasion,
Yes.
I have made the several grounds. I have made one grounds. I have that as I have proved one grounds. That I am filing that ground.
କିଛି କରନ୍ତୁନି ସେଟା ସେଠି କରିବେ
ସେଟା ମାନେ I will.
ମୁଁ ଏଟା evidence taking court ନୁହଁ I am not conducting a trial.
So I am praying from time.
କଣ affidavit ଦେବେ ନା ସେମିତି କାଗଜ ବଢାନ୍ତୁନି
Tell me, I will seeking some time.
But don't spoil the case. And how can I take evidence to prove your contention?
Not
ଆପଣଙ୍କ କୋଉ paragraph ରେ proof ମଗା ହେଇଛି ପଢନ୍ତୁ
medical documents.
ସେ medical document ରେ ଆପଣ exemption of personal appearance ନା transfer ହେଇଯିବ
ନାଇଁ
how can I ensure
he is ill
ଆପଣ ଯଦି ଶୁଣିବେ ତାହେଲେ ବୁଝି ପାରିବେ
suffering from diseases.
No court is safe for a ill person. କରୁଛନ୍ତି ଆପଣ କୋଉ କୋର୍ଟ କୁ ଚାହୁଁଛନ୍ତି
ଆମେ ଚାହୁଁଛୁ ଭୁବନେଶ୍ୱରରୁ
କେନ୍ଦ୍ରାପଡ଼ାରେ କଣ ଫ୍ୟାସିଲିଟି ଅଛି ଆପଣଙ୍କର ମେଡିକାଲ ହେଲ୍ଥ ଗ୍ରାଉଣ୍ଡରେ
ସେଇଟା
କିଛି ନାହିଁ
ଟ୍ରିଟମେଣ୍ଟ ଅଛନ୍ତି ସେଇଠି
କିଛି ନାହିଁ
ସେଇଠି ସେ
I am not sitting on ivory tower. You must understand. I have seen life very closely, places very closely. कोटी कौन अछि ताबी जानि now suppose I am moved by you and say that Kendrapada since his health condition is not good it should be at Kendrapada something happens to him at Kendrapada will you take the responsibility
my lord she is fatherless
आपण जदि इलनेस ग्राउंड रे जो भी चाहिबो पिटिशनर सेठी हबो सेटा आको केस लॉ देखंतु एटी एविडेंस नियंतु
गोटे ये
अगर को पार्ट एविडेंस पे कोइतला ऑर्डर
एविडेंस
सतेचर ऑर्डर ता देखंतु को एविडेंस दउछ
evidence my lord not evidence my lord I am stating that
अगे सेटा तो सतेचर हियरिंग हेतिला आपण को पारा को ऑर्डर रो को पारा रेफरेंस एटा कहउछनी सेटा आपण रिक्वेस्ट कर देखिया
मो सेटा ग्राउंड रे लिखितली हेल्थ कंडीशन
आगे ट्रांसफर हे परियो
सेटा I will seeking some time my lord I will file written note submission
health condition he is unable to his presence will be procured by the court जब से जिबेन घर पाखरे तो नेक्स्ट डोर रे कोन करियो
not my lord I will seeking some time I will file written note submission liberty
the Lord counsel for the petitioner written note एतरे दियंतु आपण निजे प्रिपेयर होंतु करंतु I cannot entertain written note for
last
section 24 application
last occasion one submission my lord last occasion my lordship has stated that I will pray
Lord counsel
liberty
makes submits with reference to the order dated 27/4/2026 that he may be granted further accommodation accordingly the matter is urgent केबे आसियो
छुट्टी पर आसो गोटे my lordship one prayer my lordship last occasion I have stated before my lordship the liberty to file move an application before the law and family
it's not granted it has to be
सेतेबेले तो अर्जन करे पई
adjournment देय होबल I am not here to adjourn trial court matters I am here to say that the matter should be expedited
my lordship
you must understand you are just making the contrary prayer
yes my lordship okay my lordship
as an administrative judge I ask all the courts that you dispose of the matters I cannot pass orders for adjournment of matters it is going to be governed by CPC
yes
adjournment को chapter रे अछि CPC रे
civil procedure court my
एतरे आपण application देबे
17 order 17
exactly order 17 सेठी दे मोर से पावर अछि डायरेक्शन दवा order 17 pass order
liberty my lordship
what liberty you require 70 doesn't require any liberty order 17 ने preamble रे अछि recital रे with trial liberty from the high court the order 17 application will be filed
no my lordship
yes list in the week commencing as straightforward to grant further opportunity to the petitioner
वो कमेंट 6 साल
6 साल firstly लिखि दूं the matter was heard at length 27/4/2024 the contentions of the petitioner and the propositions of law were noted in detail तापर लिखो
मैंने on the said date I will file the written note submission my lordship
written note of submissions एठी
माने
written note मोर दरकार नै आगे I don't require
my lordship
आपण written note काहे कहउछनी को बुझी परलो
तो
बहुत प्रॉब्लम है आपण को एते थरा कहली ऑर्डर ता पढंतु कोठी डायरेक्शन अछि written note देबे बोली
that has not been
काहे ताले why you are
my lordship
written note of submission
my lordship
or if it is a mandatory then I cannot prevent you it is not mandated also
my lordship
petition is enough
my lordship.
yes next
Obligement
Item 8.
I will be really obliged sir if you make submissions assisting the court to raise your bar become officer of the court these kind of submissions I will be extremely obliged
my
I always hope
my I am ready my lordship the said date my lordship I will submit
परिवार नहीं आएगा
my lordship obliged
yes please
Item may I please your lordship. My lord.
yes please
My lord, here in this case, my lord, the petitioner husband was working as a labor in a my lord, mini truck, my lord, who was met an accident on 24/2006, my lord, and he has suffered injury.
देखो लोक अदालत against it
No, my lord.
এটা মোর এটা মোর ডিটারমিনেশন রে अछि তো
OPDR रे आज्ञा
I'll take instruction.
आपण सेक्शन 8 फाइल करछंती डिनाय करी
No, my lord.
आपण सेठी 8 फाइल लकरी 226 80 फाइल करछो
My lord,
The only thing he want to the amount has been deposited, so he wants a release order.
my lord, kindly have a glance.
Your lordship.
काली गोटे सेंते मैटर थिला भुवनेश्वर खदी ग्राम देव बोर्ड After deposit of the amount, still 7,000 donor.
Donor, say, so I take instruction.
ସେ କହୁଛନ୍ତି ଯେ ହଜୁର ଏଟା ବୋର୍ଡ ଅଫ ରେଭିନ୍ୟୁରେ ରଙ୍ଗଲି ଡିପୋଜିଟ୍ ହେଇଯାଇଛି ଗୋଟେ ରଙ୍ଗ ଆକାଉଣ୍ଟରେ ତହସିଲଦାର
Sir, ଆପଣ ସେଠି ପାଇଁ 226 ଆସିବାର ନଥିଲା, ଆପଣ ତାଙ୍କୁ ଯାହା ଡିପୋଜିଟ୍ ହେଇଛି ତାଙ୍କୁ ମୁଭ୍ କରିବାର ଥିଲା। ଆମେ କଣ ଆକାଉଣ୍ଟାଣ୍ଟ? Are you the accountant or I am the accountant? Have you moved the authority for redressal of your grievances?
Yes, my lord.
Who is the authority?
As per
ଯିଏ
the-
ଯାହା ପାଖରେ ପଇସା ଅଛି ତାଙ୍କୁ ବୁକ୍ କରିଛନ୍ତି, ଆପ୍ଲିକେସନ ଦେଖାନ୍ତୁ, ଲେଖା ଇନଷ୍ଟ୍ରକ୍ସନ ନେଇଯିବେ। ଆପଣ ଆଜ୍ଞା ଯୋଉଟା ଆସିକି ହାଇକୋର୍ଟରେ କହୁଛନ୍ତି
ଆଜ୍ଞା
ଅଥରିଟିଙ୍କୁ ସେଟା କହିଛନ୍ତି ବୋଲି ଦେଖାନ୍ତୁ, so that I can ask Mr. Lenka that you obtain instruction.
as per annexure 6, my lord, at page 40
So 7, that's not important.
ଆଜ୍ଞା
Whether you
ସେଇଥିରେ
have
ହଜୁର
approached the authority and by which letter or application or communication, କଣ ଯାହା ବି whatever ସେଟା ଦେଖାନ୍ତୁ,
ଅନରେବୁଲ
so that I can formulate a order.
ଆଜ୍ଞା ହଜୁର ହଜୁର ଅନରେବୁଲ କୋର୍ଟ ଆଗରୁ ହାଇକୋର୍ଟର ଡାଇରେକ୍ସନ ଥିଲା ଯେ ସେ ଓପିଡିଆର କେସ୍
Again the problem again. Sir, the question is very simple.
ଆଜ୍ଞା
What you are seeking from High Court, have you moved the authority making that prayer, and by which document?
no my lord, we have made a representation before the collector on
Collector ତ ଆଜ୍ଞା ନିଜେ ଆପଣ କହୁଛନ୍ତି ପଇସା collector ପାଖରେ ନାହିଁ ବୋଲି।
my lord, on acknowledgement at page 41 he has forwarded the representation to the tahsildar the certificate officer
ପଇସା ରହିଲା ବୋର୍ଡ ଅଫ ରେଭିନ୍ୟୁ ରେ ଆପଣ ମୁଭ୍ କରୁଛନ୍ତି କଲେକ୍ଟରଙ୍କୁ।
ସେ ସାର୍ ସିଏ କହିଲେ ଯେ
ବୋର୍ଡ ଅଫ ରେଭିନ୍ୟୁ କାହିଁକି ମୁଭ୍ କରୁନାହାନ୍ତି? Why you have not moved the board of revenue ଯୋଉଠି ପଇସା ଦିଆ ହେଇଛି ବୋଲି ଆପଣ କହୁଛନ୍ତି? ସିଏ କଣ କରିବେ?
ଯୋଉଠି ଇନଷ୍ଟ୍ରକ୍ସନ
ସେ
ନେଇଛନ୍ତି
କେମିତି ଇନଷ୍ଟ୍ରକ୍ସନ ନେବେ ଆଜ୍ଞା? କୋଉ କାହା ବେସିସରେ ଇନଷ୍ଟ୍ରକ୍ସନ ନେବେ? ସେ ବୁଲିବେ, ସମସ୍ତଙ୍କ ଘର ବୁଲି ବୁଲି ପଚାରିବେ? ସେ how many letters he has to write, to whom he will write? What would be the basis of my order and his letter?
ये तो पिटिशनर जो 2006 रो भी
Again, 2006 हो कि 1006 हो, that is not being discussed. You are seeking a direction from the court due to inaction of the authority. So obviously the natural question is that whether you have moved the authority, there you are struggling. Question 2006 कहले, High Court order कहले, CA ताको आडू हाथ देखेले, कौन? How does it help you, sir? How do I know that ଆପଣ ଯଦି High Court को move କରି ପାରୁଛନ୍ତି, ଆପଣ authority को move କଲେନି?
ନା ଅଥରିଟି ପାଖରେ ଆଜ୍ଞା ସାର୍ଟିଫିକେଟ ଅଫିସର ପାଖରେ ସେଟା ଆକାଉଣ୍ଟ
ପଡିନି, ପଇସା ଡିପୋଜିଟ୍ କଥା ପଡିଛି।
ପଇସା ସାର୍ଟିଫିକେଟ ଅଫିସର
Question, sir.
my lord,
Sir, if you have an agenda of diverting the issue,
no I am not
nobody can help you. Both of us are equally intelligent to understand. ଆପଣ ଯୋଉଟା କହୁଛନ୍ତି ମୁଁ ବୁଝୁଛି, ମୁଁ ଯୋଉଟା କହୁଛି ଆପଣ ବୁଝୁଛନ୍ତି।
ଆଜ୍ଞା
So obviously you have to tell before the court by when you move the board of revenue where the money is there, you are saying.
ଆମେ ତ ବୋର୍ଡ ଅଫ ରେଭିନ୍ୟୁ ପାଖରେ ହଜୁର କିଛି ଡିପୋଜିଟ୍ କରୁନୁ। ସେ କହୁଛନ୍ତି ତହସିଲଦାର କହୁଛନ୍ତି ଆମେ ଭୁଲରେ ବୋର୍ଡ ଅଫ ରେଭିନ୍ୟୁ ଡିପୋଜିଟ୍ କରୁଛୁ। ଆମେ ତହସିଲଦାର ପାଖରେ ହଜୁର
ତହସିଲଦାର ବୋର୍ଡ ଅଫ ରେଭିନ୍ୟୁ ଯଦି ଭୁଲରେ ଡିପୋଜିଟ୍ କଲେ, ତହସିଲଦାର ଆପଣଙ୍କୁ ମୁଁ ଡାଇରେକ୍ସନ ଦେଇଦେଇ ପଇସା ଦେଇଦେବେ?
ତହସିଲଦାରଙ୍କୁ
ଡାଇରେକ୍ସନ ଦେଇପାରିବ? କୋଉ ପ୍ରୋଭିଜନରେ ଅଛି?
ଅଲରେଡି ଆର୍ଲିୟର
Is it not a government account?
ଆଜ୍ଞା
ସେଇଟା ତ ତହସିଲଦାର ତାଙ୍କ ଘରକୁ ନେଇଗଲେ କହିଥିଲେ ମୁଁ ତାକୁ ପର୍ସନାଲ ଆରେଞ୍ଜ କରିକି ତାଙ୍କୁ ଆଣିକି ଅଟକେଇକି ରଖିଥାଏ।
ये लक्ष्मी काली से annexure 5, page 39. The Tahsildar has requested the member board of secretary of OP2 to place the matter before the certificate officer and Tahsildar. That is pending. Yes, page 39, annexure 5. Last para. Hence, I am requesting you to kindly place the above mentioned MSCT amount of rupees 100 in favor of the certificate officer come Tahsildar Kania for disbursement. That is pending because the OP2 that remember. In the middle of the para, it has been mentioned that
This is reference to? Is there no reference?
no reference. Only reference to that MSCT case number 34/2006.
That should have been your submission, mister. If your learned colleague can find it out, you could have said that also. Mr. D.N. Lenka for the AGA for the opposite party. The petitioner, the petitioner before this writ application is the wife of deceased MACC case order to is the $49. और ता हस्बैंड का नाम कौन सा?
सुरेश चंद्र नायक
सुरेश चंद्र
नायक
ये तो पार्टी ना पेज 15 देखिले
ଆଜ୍ଞା ସେ ମରିଗଲେଣି ହଜୁର ସେ ମରିଗଲେଣି
କି ମରିଗଲେ
ସୁରେଶ ଚନ୍ଦ୍ର ନାୟକ ମରିଗଲେଣି
ସେଇଥିପାଇଁ ତ ପଚାରୁଛି
ଆଜ୍ଞା
ତାଙ୍କର ୱାଇଫ ଯିଏ ସେ ପାର୍ଟି ଅଛନ୍ତି
ହଁ ସେ ୱାଇଫ ଏଥିରେ ପିଟିସନର ଅଛନ୍ତି ହଜୁର
अरे केस रे एमएससीसी केस रे
ନା ହଜୁର ଏମଏସସି କେସ ରେ ସେ ବଞ୍ଚିଥିଲା ବେଳେ ନା କେସ୍ ସରିଗଲା ପରେ ମଲେ ସେ 2023 ମସିହାରେ ହଜୁର ମଲେ ହାଇକୋର୍ଟରେ ଯେତେବେଳେ ପେଣ୍ଡିଂ ଥିଲା ମ୍ୟାଟର କେସ୍ ଚାଲିଲା ବେଳେ ହଜୁର ସେ ବଞ୍ଚିଥିଲେ ଆୱାର୍ଡ ହେଲା ବେଳେ ବଞ୍ଚିଥିଲେ
क्लेम केस रे जी थिले पिटिशनर
ଆଜ୍ଞା
ତାଙ୍କର इंजुरी पे पैसा पाइले
ଆଜ୍ଞା ତା ହାତ ଗୋଡ ଭାଙ୍ଗି ଯାଇଥିଲା ଲଙ୍ଗ ଇଞ୍ଜୁରୀ ପାଇଁ ହଜୁର ପଇସା ପାଇଲେ ବହୁତ ଦିନ ବେଡ୍ ରିଡେନ୍ ହେଇକି ରହିଲେ
ସେ ତାପରେ ସେ ପଇସାଟା ତାଙ୍କୁ ମିଳିନି
ତାଙ୍କୁ ଏ ଯାଏଁ ମିଳିଲା
ତାହେଲେ ହାଇକୋର୍ଟ କେମିତି ଦବ ଏଟା
ନା ଏଇଟା କଣ ହେଲା କି
ଏଟା ତ ଗୋଟେ ଡିକ୍ରିଟା
ନା ହଜୁର ଏଇଟା କଣ
ଡିକ୍ରିଟା କେମିତି ଆପଣ ହଜୁର କହୁଛନ୍ତି ଆପଣ ଟିକେ ମତେ ହଜୁର କହିଲେ ଗୋଟେ ବହି ଫହି ଦେଖନ୍ତୁ ଟିକେ କୋଉ ପ୍ରୋଭିଜନ ରେ ଗୋଟେ ଡିକ୍ରି ଅଫ ଏ ଟ୍ରାଏଲ କୋର୍ଟ ୱିଲ୍ ବି ଡାଇଭର୍ଟେଡ ବାଇ ଦ ହାଇକୋର୍ଟ
ଡିକ୍ରିଟା ହଜୁର ସେମାନେ ଚ୍ୟାଲେଞ୍ଜ କଲେ ଗୋଟେ ଏକ୍ଜିକ୍ୟୁସନ ପ୍ରୋସିଡିଂ ରେ
just let us ଆପଣ the way you are ମାନେ changing the track will not help you sir
annexure
Why, if you are unable to answer better to keep quiet because I'm asking you a serious question in your interest you must understand that ଆପଣ ଟିକେ ପଢିଲେ ଅର୍ଡରଟା କୋଉ ପେଜରେ ଅଛି ଅର୍ଡର
26 minutes
ପଢ
and the result of MSc is allowed on ex party against the opposite party number 1 and dismissed against the opposite party number 2 on contest. The opposite party number 1 is directed to pay the deposit an amount of rupees 90,000 within a month, hence failing which the compensation amount
90,000 କାଇଁ ପଢୁଛ
95,000 within a month, hence failing which the compensation amount will carry interest at rate of 9% per annum for the date of filing of this above application till redressal of the same.
2008 so tapare when it was deposited and when he died
Lord, it was deposited on 15th thereafter my lord the certificate case was issued in certificate proceeding my lord
who filed the certificate case
the petitioner, the claimant of this code below, my lord MSc, has filed a certificate case, and in that certificate, one execution for execution and warrant has been issued, and that warrant has been challenged before this honorable court in WPC number.
ଆପଣ ବହୁତ କଥା କହୁଛନ୍ତି କିନ୍ତୁ ଯୋଉଟା ପଚାରୁଛି ସେଟା କହୁନାହାନ୍ତି ଏବେ asked you that ତାପରେ କଣ ହେଲା WPC ଫାଇଲ ହେଲା କି ନାହିଁ so I am asking you କେବେ ଡିପୋଜିଟ ହେଲା ଡେଟ୍ ଟା ପଚାରୁଛି ଆପଣ କଣ କହୁଛନ୍ତି ଆଜ୍ଞା
deposit ହେଇଛି 5/5/2015 डिपोजिट ହେଇଛି।
को प्रोसीडिंग रे
एग्जीक्यूशन प्रोसीडिंग
ओपी नंबर 1 की थिले की
ଆଜ୍ଞା ସେଥିରେ ଓପି ନମ୍ବର 1 ପିଟିସନର
रश्मिनी साहू
ଆଜ୍ଞା ରଶ୍ମି
एमएससी केस रे की ओपी नंबर हु वाज द जजमेंट डेटर
ମାନେ ଦ ଓନର ଅଫ ଦ ଭେହିକଲ
ओनर ऑफ द व्हीकल
ଆଜ୍ଞା
सो ओनर ऑफ द व्हीकल केम टू हाई कोर्ट
ଆଜ୍ଞା
तापरे
for stay of the NBW and
Yes.
the Honorable High Court was pleased to stay the NBW subject to payment of rupees 80,000 subject to the deposit of rupees 80,000 before the certificate of sorry. And that rupees 80,000
इतरे आपण 4A to 4D हले लीगल हेयर्स
again
so what happened to the other legal heirs
4A होचंदी मा for BCD
so
होचंदी
that was the question asked to you that how this court will substitute the legal heirs of a decree holder without eliminating others now here only one legal heir is here
जो से रीट रे से जो अपने
से रीट कोन हो
जो WPC
से रीट रे कोन एमएससी ऑर्डर टा मॉडिफाई हे गला has the court modified that
आगे ସେଥିରେ
where modified here by the order is modified the decree holder has are deleted
we filed a substitution petition the lordship had a kind glance to
आपण देखिना
page number 34
पेज नंबर 34 नो रीट रे कॉन्स्टेंट लेसन केने भी ही पर पेज 29
आगे
4A 4B 4C 4D
आगे
तो बर्तन जेडा 4A केमती हे गला BCD कोडे गले
BCD हजूर साइड एनओसी ଦେଇଥିଲେ ଯେ ସେମାନଙ୍କ ଏ ନାଁରେ ମାଙ୍କ ନାଁରେ ସବୁ ପଇସାଟା ଆସିବ
कोड देले नोस काई कॉपी काई
ହାଇ ହଜୁର ଏଟା ଦେଇଥିଲେ ଅର୍ଡର ରେ ହଜୁର
प्रिपेयर ही आतंतु this is not the way you argue a matter
page
and you must
30
understand these people are suffering you are representing causes of person who are not aware of law they are suffering for a amount of rupees 80,000 or whatever they are moving around since 2008 and don't add to their agony
34
by not understanding the implication you are adding to their agony आपण एनओसी कथा लिखिछन रिट पिटिशन रे प्रेजेंट रिट एप्लीकेशन रे
sir at page 34 since the opposite
अरे
party
कोन जहा पचले आवडे कथा कहउचंती
sir ସେଇଥିରେ
have you written anything regarding the NOC the
yes sir,
present
yes, sir. I have filed an affidavit before this
which
court.
paragraph आपण रिट रे
That
paragraph
is
लिखिछन
in read
रिट रे एफिडेविट रे कोट लिखचंती पैराग्राफ आपण रिट एंड्स एट 12 आपण 34 कहउचंती
no, no, in page
oh my
34
lord your read starts at 1 ends at 12
at page 5 I have taken a reading that the victim who was the OP number
paragraph reading कहबे सर एम्ति कोन
paragraph 7 my lord paragraph 7 at paragraph 7
yes
that the victim who was made as OP number 4 in the writ petition died in the meantime on 22nd 9 2023 and his legal heir was substituted in WPC
so
number
आपको बुक होच that I pointed you out
again
that is what I am asking you that you are rather you are saying that what I was told that when there are ABCD 4 legal heirs how it can be confined now to only one legal heir you said that they have filed NOC then you said then where is the NOC then you said that they have filed in the writ petition then the question is that where is the NOC
and that
then you are referring to page 34
that order in the order it has been reflected
you must state that on oath in the affidavit pleading it has to be there because people annexure is not supported by affidavit annexure is not part of the affidavit you must understand that
but may
ଆପଣ ଟିକେ ପ୍ରିପେୟାର ହୁଅନ୍ତୁ ଆଜ୍ଞା ସବୁ ଯାକ make a comprehensive preparation so that you assist the court to do something. Upon the convoluted koridewe facts ke bhaliya, it becomes impossible, and that too it is not a, it is a civil court decree. Civil court decree, no court has authority to modify by exercising writ jurisdiction. 227 there is no authority of the court. But it has padiले page 6 टा author.
His hires, who was OP number 4A in the writ petition, WPC numbers 21523 of 2024, the WPC number
Yes, plural लिखले who was ता परे कर देले, who where हवा कथा 4A to 4D. The petitioner, learned counsel for the petitioner is heard at length. The petitioner is one of the legal heirs of the deceased beneficiary, who was the claimant in MSC case number 34 of 2006 before the Additional District Judge -4th Motor Accident Claims Tribunal, Talche. By our dated 12 August 12/8/2008, the learned MSCT allowed the claim of the petitioner since deceased with the following order. Order ta paibe page 26 re. Stop. Para. Subsequently, unfortunately, the claimant decree holder has passed away.
that he was passed away
In the year around
2023.
Around the year 2025. 2023.
22/9.
ଆପଣଙ୍କର ସାର୍ଟିଫିକେଟ କେସଟା ଯୋଉ ଇନିସିଏଟ ହେଲା ସେଟା କୋଉଠି ଅଛି? ସେ ଆନେକ୍ସଟା କୋଉଟା? For execution of the decree, certificate case was initiated. Certificate case କିଛି କାଗଜ ପତ୍ର ଅଛି ସାର୍? Certificate case was initiated by the MSCT.
No, the certificate was the certificate officer.
अरे initiator sir, certificate officer होचंती जे presiding officer of certificate court जो OPDR रे certificate officer होचंती तहसीलदार, सब collector और ADM collector भी तांकर pecuniary jurisdiction अछि. अब ताकू आपण जे जज को कहिबे सेठी होचन सी होचन हाकिम कोन के इनिशिएट करबे ही इनिशिएट करले
4 MSCT. 4th MSCT.
कहले सेटा MSCT आपण कहले तहसीलदार.
No, 4th MSCT.
We submitted that due to non-payment, due to as the decree was not satisfied against the OP number 1 in the MSC application, that is owner of the vehicle, Srimati Rasmini Sahoo. A certificate case was initiated by the learned MSC, MSCT.
4th
MSCT, Talche, before the before the authority, that is Tahsildar, dash come executive magistrate, comma Konia. The certificate case number koi paribe?
One of 2011.
That is certificate, that is OPDR case number 01/2011-2012. The certificate was issued on 30/6/2014 against the judgment debtor, owner of the vehicle. Thereafter, the judgment debtor moved this court by filing WPC number 21523 of 2014. This would be the last matter before recess. After recess, I will continue. So you need not wait. Please go and have your lunch. Because you don't have the facility of just having the lunch behind. That difficulty I used to face. Many times you reach the canteen, the case will be called. Yes, Podigal. This was said. In fact, whoever visited the court had the same issue because they you can't travel that much. Anyway, yes.
After I beg pardon.
Madam, your matter will be taken up after recess.
Madam,
Sir.
I beg pardon. After all, I have a personal one.
You please assign Mr. Prabhu, Mr. Prem.
Okay.
Sir, Becky, WPC number 21523 of 2014, wherein the legal heirs of the deceased decree holder were added as 4A, 4B, 4C, 4D. The cost title of the said stop query, the cost title of the said applicant petition is available, marked as Annexure 3, which indicates 4A, 4B, 4C, 4D reproduce for them. The insurance company has been added as OP number 5. The said petition was disposed of.
Yes.
Disposed of by order of the coordinate bench dated 22/7/2024.
Para 7, 8 and
para 6 टा पूरा करिया पड़ो
6 to 9.
6 to नहीं कि पूराटा आपण
9, 10.
11 जाए कर देबे
11.
6 to 11 टा रिपोर्ट
Yes.
The allotted counsel for the petitioner refers to annexure 5 to the writ application, which is also endorsed by the allotted AGA. That is a letter from the
Tahsildar.
Tahsildar actually se no. Se hochone kono? Certificate officer.
Yes.
Certificate officer dash com dash Tahsildar. So se jente chithi lekhcheni takara RDC is much higher. Se RDC tanko pore ye jo. Sorry, board of revenue. The certificate officer come Tahsildar has written a letter by office letter refers to it endorsed by the allotted AGA. Stop. By the said letter annexed as Annexure 5, office letter dated as Annexure 5, 14/10/24. The Tahsildar come certificate officer has written to the member secretary, Board of Revenue, Odisha Kotak, for placing a fund of disbursement in MSC case number 34 of 2006. Stop. The allotted AGA shall obtain instruction, the further steps taken from the office of the member secretary, Board of Revenue. The allotted AGA is apprised of the fact that the beneficiaries of the award in MSCC 34 of 2006 after even 20 years of initiation of the matter, are still awaiting the benefit. So, kebe asle habo, Mr. Lekha?
You also call it after vacation.
Myself will listed for orders in the week commencing
29/6.
on 30/6/2026. The parties are lacked upon copy दरकार ना website copy रही जो.
Website.
The parties have the liberty to act upon the website copy of the order, today's order, obtained from the official website of this court.
May I pardon?
Yes, please.
Item 28. I appeal for the petitioner, Mr. Bibi authorized for all the power. With parties.
The other side to call it date due.
No, he has told me that he is out, out of station. I pray for next week any day.
बहुत बड़ा है sir.
No, he telephoned me that he is out of
Right,
station.
right. Next, sir, wherever both parties are suggesting a date, just he will give you.
Next week any entry mode to
Next week रे period.
after vacation.
Entry order देखियो पड़िबो आपण मार्क करि थांतो. Entry order देखि जल्दी की.
Aye.
Adjournment na stay.
Stay payment.
Stay ताल it is not been touched, simply adjourn. Will continue. देखि देबे.
And there is also.
केबे date कले?
We comes in 6 sir.
Yes. How do you capture it?
I don't know, 9 miler, we have challenge only.
Again,
PLA order,
just-
PLA order to
Sir, please, sir, I have to come back. Judicial order has to be passed. Other side will inform करछनी.
Because
Other side will inform करंतु. Inform the other side.
Item.
ହେଲା? Adjournment ଚାହୁଁଛନ୍ତି ତ? Adjournment ଚାହୁଁଛନ୍ତି, date ଚାହୁଁଛନ୍ତି?
No date, because I want that this matter kindly be taken out.
Date out of the नहीं होगा. We'll go serially. Let us see.
Item number 35. Mediation.
Out of the नहीं होगा. Yes.
Item number 35. Mediation report has come to file 13 let's take up this matter next week any date minor. Next week is
ठीक है, रुको तो देखिए बा. Let us reach that. Because that has to be, order has to be passed ना.
Yes,
Right,
sir.
right.
Yes.
Also, it has to reach. देखिए बा. होला?
Item 9.
Minor.
The
Minor challenge is
SK Gopal for the petitioner.
PLA matter minor.
Yes.
The challenge is the order of the PLA on dated
Grounds, sir. Grounds.
grounds, but actually, survey has given the report assessment is 6,72,000, but PLA has not been considered. Sir, I'm going to fact.
Fact जाइए बोले.
Our survey
ground is set
ground
up to the ground for which
ground-
you are challenging.
ground of sir, you funny.
Have you agreed or not?
No,
Have
no.
you agreed before
No,
the
sir,
PLA?
as per the assessment, we have the insurance company, we have appointed the surveyor.
Sir, when I ask you a question, answer that instead of giving your speech.
My lord.
Have you agreed before the PLA for the matter to be disposal, signed the agreement or not?
No.
Not. So first, you should raise that contention first. That we were not party to the agreement or we have not agreed for the disposal.
No. My lord, I am the insurance company. The award has been passed against our insurance company. Then we have to challenge that order.
एक कथा काहेकि भाबुଛନ୍ତି जज भाइपर ना इंश्योरेंस कंपनी बोले आपण why you are presuming that सेटा बुझी के और 3-4 स्टेप I am ahead of you. The insurance company is a party to the case or not?
Yes, ma'am.
Now the insurance company has agreed for the settlement or not?
Settlement.
Agreed.
Yes, my lord.
Then how you can challenge it?
But how, because as per the assessment of the surveyor, independent surveyor, the
Sir,
amount has been fixed.
Military challenge kari hoga na. Have you read the judgment?
Say,
Which judgment you are relying on? To challenge a order in permanent local adalat. After you have agreed there, signed the agreement, and the court has proceeded to pass the award. Which judgment?
my lord, the assessment.
This is not an appeal. You must understand that. Appeal does not lie. What you are arguing is against you. If you start arguing, assessment order was ex parte, the amount was not determined, those things have to be taken before the trial court. In the trial court, you have agreed. Now you are turning around.
No, we
You
have
taken a U-turn.
no, we have not. As per the assessment.
As per assessment, ଆପଣ 5 ଥର କହୁନାହାନ୍ତି.
Same time we do ଚାହୁଁଛୁ, but ସେ ତ ନବା ପାଇଁ ମନା କରୁଛନ୍ତି. But court has not been considered. Award has been passed 50 lakh something. So
Sir, answer that. You answer the query, or I'll record that you will not answer the query. You have a choice. Have you agreed to the settlement or not before the trial court or not?
we are ready to settle settlement. But as
Have
per
you
the-
agreed? So then no case.
ଆମେ ସେଇ amount ଯୋଉ amount assessment କରୁଛୁ
ଆପଣ ଏମିତି ସେଇ amount indeterminate କୁହାଯାଏନି.
ସେଟା
ଆପଣ if you want to challenge, you have to read. First of all, you must understand that you have to tell your client, the insurance company, that local adalat order should not be challenged by insurance companies. Because you are carrying, you must understand that we are also involved. We know what is happening in the local adalat. Lot of effort is made, lot of persuasion. Pre-local adalat conciliation is made. There the parties agree, then they sign, then they present to the court. Then it is passed. That cannot be ground, this assessment value cannot be a ground for challenging a local adalat award.
whatever they have been claimed, my lord, the claimant, applicant has been claimed in the PLA. So that amount should be at least considered as per the report of the surveyor. Surveyor जो रिपोर्टर सर दउचंती ताको तो बेस करके हमें करिबा से जो कंडीशन ताको से करके से गोटे ऑर्डर कर देला
Absurd. You are talking absurd, sir. You agreed for that settlement before the trial court. Now you are turning around. Why there is a change of mind of you.
हमें
The
कहया କଥା
questions you are raising, you should have thought that before agreeing to the settlement.
से
You cannot raise those questions after you agreed for the settlement in writing.
जो ऑर्डर टा
This
पास
would be dismissed with heavy cost.
सर से जो ऑर्डर टा पास
I will impose 5 lakhs cost on the insurance company because I owe a duty to law. Unscrupulous insurance companies should not tinker with the process of adjudication, settlement in Lok Adalat. You should not accept these kind of briefs.
परमानेंट
You are an officer of the court.
सर
If you have agreed, you have settled, you cannot turn around.
ଏଟା परमानेंट लोक होतला जोटा ट्रायल रे ହେଲା ସେମାନଙ୍କ ବେସ୍ କରିକି ସେ ଯୋଉ सर्वे रिपोर्ट ଟା
Sir, are you agreed or not, sir? Whether you will answer or not.
सर काइंडली भी काइंडली स्टेट अनदर डेट मानो आई विल गेट द इंस्ट्रक्शन
Sir, not at your instance.
सर इट्स माय
Sir, you are not conducting the court.
सर इट्स माय
Judge is conducting the court.
इट्स
Must
माय
understand that.
प्रेयर काइंडली भी अलाउ वन टाइम वैकेशन पर आसो सर
It is my request not to conduct the court.
सर ठीक है
No, you are crossing the limit.
सर
You
इट्स
are
माय
crossing the limit.
सॉरी माय लॉर्ड
I have no, you can't answer. Sorry. Have you agreed to the agreement, the settlement or not?
आई विल गेट द
So you
इंस्ट्रक्शन
have said yes. I will record that.
सर एटा मु टिके इंस्ट्रक्शन टिके नेबी काइंडली एटा पोस्टर
Sir, कहतुनी कि मु आपन my lord कहबिनी. Don't disturb the court while passing the order. Be responsible.
My lord, kindly be posted after.
No.
Sir, not give the instruction, man.
Conducting the court. You are not the presiding judge here.
My,
That you do as a presiding judge, not as a lawyer.
my lord, kindly be consider my prayer.
Sir,
Kindly,
kindly don't disturb. Kindly become a lawyer in a court. You are not agent of your client that you will not answer and you will go away saying that kindly my lord answer. Why should you say kindness? You are fighting somebody's right. Court is not that big.
My lord, kindly
The petitioner insurance company before this
after
court,
vacation, my
that
lord,
is
kindly.
SBI General Insurance. After agreeing before the lauded Lok Adalat, in the National Lok Adalat,
Sir, permanent local sir. परमानेंट लोक
For
ट्रायल
agreeing
ହେଇଥିଲା
for the permanent local adalat into bracket public utility services Khurda Bhubaneswar.
ସେ ଯୋଉ ଟ୍ରାଏଲ
PLA
କରିକି
case number 35 of 2020. In an application under section 22C, capital C to bracket 1 of the Legal Services Authorities Act 1987. Challenges the said order. Challenges the award by the PLA. The application was filed by the opposite party. The Goddess Rice Mills as the applicant before the PLA. The award was made on 23/12/2025. The deponent in the present writ petition. The petitioner, the deponent representing the petitioner in this the petitioner shall file affidavit clearly stating whether they had agreed before the learned Lok Adalat for disposal of the matter in terms of the award made. So, if they had agreed before the learned Lok Adalat, before PLA, then the reasons for turning around and challenging the same by filing the writ petition. The petitioner herein shall produce the attested copies of the office records in which decision was taken to challenge the award of the Lok Adalat. Needless to say that the affidavit shall be filed by an officer having authority and responsibility to do the same. The matter shall be listed in the week commencing 18/5/2026.
मतलब after
Affidavit file करो
after vacation.
tomorrow. Bargain कले Monday.
Sir, इसमें परसों से कलकत्ता में.
Whatever.
Sir,
Sir,
it's my prayer, sir. Kindly.
Sir, I can ensure his presence. If you say that, I'll record and ensure his presence.
It's my prayer, sir. Kindly.
Sir, you also consider my order. I have considered your prayer. Sir, I can't support you in your machine in this activity of turning around.
Only my
That is not mandate.
Kindly consider after I have to carry out the order, my lord.
Matter shall be listed on 13/5/2026 marked at 10:30 p.m. Failure to file the affidavit. The petitioners.
Sorry, my
representatives shall appear in person.
my lord, sorry, kindly.
Sir, either you file or you appear in
It's my
person.
prayer. Again, I am
That's it.
kindly consider, my lord. At least.
Sir,
Your previous order, kindly.
above order. The above order is
Later.
passed
20th.
considering the law laid down by the Honorable Apex Court in Jalor Singh versus State of Punjab. Bhargavi Construction versus Kuthakapu Mutham Reddy. Dilip Mehta versus Rakesh Gupta. Bhargavi Construction got enough. Bhargavi Construction larger than this. It is a matter of concern that a insurance company, after agreeing before the permanent Lok Adalat, as stated by the Lord Council, on being pointedly asked that they had agreed, has decided to challenge, decided to indulge in further litigation. Which is contrary to law. Sir, they have to obey you. they will realize what a lawyer means.
Sir,
This is the problem. When you do not stamp your authority, this will be the problem.
sir, PLA ରେ trial ଟା ହେଲା ପରେ they have been served the notice to us, then we have been appeared, then filed the written statement.
Sir, ଆପଣ ଯଦି
After the all
ଆପଣ ବି
details-
ଭଲ ଓଡିଆ କହିପାରିବେ।
ତ
ଆପଣ କଣ୍ଟେଣ୍ଟଲି ପଚାରିଲେ ଯେ ଆପଣ agree କରିଛନ୍ତି କି ନାହିଁ?
ନା sir,
ଆପଣ agree କରିଛୁ।
agree କରିନୁ, ସେଟା by mistake ମୁଁ
Affidavit
ବୁଝିବାଟା
ଦେବେ?
ଭୁଲ ହେଇଯାଇଛି।
ସେଟା affidavit ଦେବେ।
ହଁ sir, ମୁଁ ଦେବି sir, ସେଟା।
ଦେବେ, 13 ତାରିଖ ଦିନ
Date ଟା ଟିକେ sir,
Sir, 12 ତାରିଖ ହବ।
sir,
Today, as a lawyer, I did this like you, and I was compelled to ensure personal appearance at 2 p.m.
sorry, sir.
Mr. Mishra might have, I can remember.
Sorry, my lord.
No, I'm extremely sorry. Bargaining by a lawyer for these reasons are not good. You are looking at the convenience of the parties. You should not. I have granted you sufficient time till 13. It is 5 days. Do you know the travel time to Kolkata? You must be traveling
ଲୋକଦାଲଟି ଅଛି sir.
1 hour.
ଲୋକଦାଲ 9 ତାରିଖ ଅଛି sir, ସେ-
Whatever. Look at ପରେ ସେ affidavit file କରିବେ if they are here. This is not the way, sir. ଆପଣ ଗୋଟେ ଦିନ କୋର୍ଟରେ କହିବେ, ପାର୍ଟି ଆସିବେ. There will be a lot of, you see, these are being published in newspapers. This is monitored by High Court, by Supreme Court. If you do not, if you have not agreed that affidavit has been filed, what order has been, there is no adverse order against you also.
My personal difficulties there, sir. I was
Sir, personal difficulty I cannot look at, sir.
Here,
Sir,
I need to consider one
court's difficulty is also a difficulty. The lawyer process for the petitioner, shall I record and reject it?
sorry, sir.
Please.
କରନ୍ତୁ sir, ମୁଁ ଏଇଟା ଆପଣ
Sir,
Sir, whatever-
it is not your personal case. Don't identify yourself. They must respect and honor your words. They can't dictate terms with you. 13th, that shall be listed to be taken up at 14th of May at 10:30 p.m. Failure to file the affidavit. In case of failure to file, the authorities shall appear in person.
my lord, 13 ଟା ଥାଉ, my lord, 13
ଅସୁବିଧା ବୋଲି ରିପୋର୍ଟିଂ କରାଗଲା।
14 ହବନି, 14 ମୁଁ ସେଇଠି କହୁଥିଲି କି sir, 20 କହୁଥିଲି ଯଦି ଆପଣ ନ
20 ହେଇପାରିବନି sir।
15 15
11 କର।
sir 13 ଥାଉ sir, ଟିକେ ମୋର
11 ଥାଉ sir। ଆପଣ ଯୋଉ
ପ୍ରେୟାର କରୁଛି sir,
ଆଜ୍ଞା ମୁଁ ବି ପ୍ରେୟାର କରୁଛି ଆପଣଙ୍କ ପ୍ରେୟାର କରୁଛି ଆପଣ
କରିବେ
I have told you.
sir, ଯାହା
I have said.
sir 13
I have said ଏମିତି କରନ୍ତୁନି। I have suggested ଏମିତି କରନ୍ତୁନି। If you bargain, I will change the order. ତାପରେ ମୁଁ ଅର୍ଡର କଲି। ଆପଣ ଦେଖିପାରିବେ। I have requested you.
13 ଥାଉ sir, 13
13 ଠିକ ଅଛି 13। Margaret 10:30 p.m.
Item 12,
The Vasudev Mishra for the petitioner, opposite party. Nank.
May I please, Your Lordship? So that's been filed the prayer Miller to direct the law and Judge Family Court Jaipur Miller to dispose of the CP number 50 of 24 Miller within a stipulated period.
So that order cannot be passed. Supreme Court has passed strictures against High Court, Constitution bench. If you want, I can provide you the copy. So I will just say that if you make an application, that's it.
No, what happened, Miller?
So then I am passing it over. Just go through this.
Miller.
That will definitely benefit both of us because we'll be spending time on this.
Right. I can often.
No.
Represent-
As it seems, I mean, knowing you, I mean, you are so reasonable. You will have to have looked at it. Only two paragraphs of it, but it's a constitution.
Miller.
The 41 तेईस टा पढ़ो. Just go through. Pass on.
ଏଇଟା ମୁଁ ଦେଖିବି ଆସୁ ପରେ ଆଉ
ନା
ଏଇଟା କଣ ହେଇଛି କି
This matter should not be ଆପଣ ପଢିଲେ ବୁଝିପାରିବେ.
ଆଜ୍ଞା
How serious your consequences. ଆପଣ ଯୋଉଟା କହୁଛନ୍ତି,
ଆଜ୍ଞା
how the Supreme Court has dealt with. Supreme Court has dealt with that. Actually.
ଆଜ୍ଞା
ତାପରେ ଏଇଟା ବି ଦେଖ. Next. 41 ଦେଖନ୍ତୁ ତାପରେ ଜଷ୍ଟିସ ଓକର ପାରାଗ୍ରାଫ ଟା ଦେଖନ୍ତୁ. Just put this ଛୋଟିଆ ଗୋଟେ. Yes.
item 14.
अच्छा ठीक अच्छे तापर नेक्स्ट पास ओवर करो तो तो कमिला कौन है लगे पास ओवर ठीक अच्छे और ठीक है 16 15 टा
That's a talk.
हम्म,
Talk about
अच्छा मिस्टर पीके महांती नहीं सॉरी मिस्टर एस सतपथी फॉर द पिटिशनर Prem Kumar Mahanti, Additional Standing Counsel for the opposite party. Item 15, Mr. Mahanti.
Yes, Your Lordship.
Prem Kumar Mahanti for the opposite party. The matter was presented before this court on 18/8/2021. Thereafter, it was listed on 1/9/20 and 26/8/20 for the coordinate bench. The memo, the allotted counsel for the petitioner refers to the memo dated 6/5/2026, which states thus: the lekha the petitioner is seeking for bracket district lecture. Accordingly, the petition is disposed of. The writ application is disposed of. Yes.
16.
Pass over question, please.
17.
16 upon
68. No.
pass over.
Pass for sir asked. The
ठीक है,
3 PM
70.
fix thila ta.
Yes, yes. Passed over. Already passed over. Yes, 17.
17.
Passed over.
18.
18, yes, Mr. 18 टा की मेंशन करते करिए बोली मिस्टर सेठी आपण 18 करिवे ना
this is assigned to Prem sir.
से आसो ताल
Yeah.
यस ओके 19
19.
For the opposite party in the first.
यस
Wait, please, Your Lordship.
यस
I was served with the IA yesterday, my lords. I need to seek
हैव यू
instruction.
रिसीव्ड द पिटिशन और नॉट
Petition I had received. The IA
so IA
IA was filed later.
fair enough
IA is
if you
also-
have received yesterday I have to consider that
Very well. I need to.
even without serving I have to consider that because I have to see the prayer but if you have not received the petition then please tell that
No, petition I.
okay. So, because it's a matter of 25
I filed my counter also.
counter not to be entertained in a revision application.
And
Have you checked the law?
I just wanted to place some facts.
Oh yes, can you?
Not sure, my lords.
Please don't make that. Develop good habits as a lawyer. You are arguing a revision, opposing a revision. So check whether I can entertain. Suppose possibly you can say that I can entertain counter and other things. It's not a writ application. In revision, the revisional court cannot go beyond the pleadings before the learned trial court. Whose decision?
I have to verify.
So whenever you come to the court, develop a habit of reading something. Yes, Mr. Perda?
Yes, Your Lordship. Lordship, the corrected matter, RPFM 70 of 2026,
Yes,
there is a 125 proceeding before the family judge Nayagat.
yes.
And initially, the husband did not appear before the court. He was set ex parte. An interim maintenance order of 30,000
Take
was
your
passed.
seat. Take your seat.
Interim maintenance amount of rupees 30,000 per month was passed. Subsequently, my lord,
So you spend your time doing some also reading. That would help you. Whether you can file.
if Lordship kindly refer to my
Read 20.
date chart, please.
Paragraph 20 the street. Yes.
Yes. If Lordship kindly refers to my date chart, I have mentioned in detail what happened. Thereafter, 30,000 was passed interim maintenance, 22/11/2021. The learned family judge Nayagar passed that order. He did not pay despite that. Therefore, execution petition was filed. NBW was issued. Thereafter, the husband came before this Hon'Ble court. This Hon'Ble directed that in husband's application, he wanted to set aside that ex parte order and to quash that order of interim maintenance. This Hon'Ble Court directed Answer 5 to attach the salary. Thereafter, he withdrew that his application and then contested. Your Lordship had order dated, judgment dated, I'm sorry, judgment dated 28/7/2025. The Learned Family Court, Nayagarh, fixed the passed the final judgment, fixing the maintenance amount 16,501 rupees. It is a reduction of almost half the amount. Challenging that, I have filed this revision.
So the earlier amount was fixed.
30,000.
Was supposed to be 125.3. The modification was 5.
No, Your Lordship. No modification. Only 125 proceeding. I filed the more.
No, when you are saying earlier amount was reduced, what do you mean by that?
That interim amount.
Interim amount. Interim amount.
I'm sorry. I could not make it clear. That interim amount was 30,000. Subsequently, in final judgment, it was fixed at 16,501. Challenging that, I have come in revision before this Hon'Ble Court.
Your application is 264. 264. You are challenging that
yes.
Final order.
Yes.
And the connected.
It has not been copy. Has not been solved.
Somejit Mahanti.
Yes, Mahanti, you are there.
Yes, sir.
So your application, you are challenging the 16,500.
Indeed.
Okay.
And in that, as it seems here,
it hadn't come up, my lord.
Delay
First
is
time
there.
it has come up.
Delay is there, and that delay has not been condoned.
First time it has come up.
Yes.
So let us take you place your matter.
Balance.
Have you completed reading para 20?
Indeed.
Yes. Yeah, hand it over back.
Great.
So what are the grounds one can challenge? Now we are upon here. I have discussed. Or you can listen, of course. So the best part of this profession is that you always, once a student of law, always a student of law.
Indeed.
What are the grounds you can challenge?
One of the major grounds is a manifest error in the order of reduction.
And if you mark that there is a say that the court has held. No criminal court should have interfered with the reason on the base that it would have arrived at a different or another conclusion. So that is a direct, it's a direct control, comment on the court not to assess again.
Yes, sir.
You have to go by the pleadings there.
Indeed.
Yes. Manifest laws. The language is not manifest. Sanctuary of errors.
Thank you.
This is written by Honorable Justice Deepak Mishra. His language is yes. Yes.
Before I go to the impugned judgment, I may be permitted to refer to the objection which they have filed in the before the learned court below.
Your Lordships would kindly, I'm actually appearing, Mr. Mahanti is the record, I'm actually appearing. Your Lordships, I had actually conducted the first round of litigation.
Yes.
Your Lordships, they have actually given us a miscase yesterday.
I understand, but it is their case. The case has been served. That this is a matter of 2025. The copy has been served. I am considering the main matter. I am not considering the IA.
No, Your Lordships, what I beg to understand is, Your Lordships, this matter was actually adjourned to a particular date. So we were supposed to take a little bit of instructions because the allegations which has actually been made is false, Your Lordships. Everything had been paid, and because she vehemently never participated in the.
But if the counsel is submitting, allow him to submit on the petition. I am not taking up the IA.
No, all that I'm saying is.
Because being instructed, Mr. Mahanti told me that. I told him that I am not taking up the IA. He said that IA has been served yesterday. So.
I have a very other day. If we can come on Monday, I would like to address Your Lordship.
But let me hear Mr. Parda on his petition. I am hearing his, not IA. Yes, Mr. Parda.
If Lords kindly turns to page number 48, their objection before the learned court below. That 48. Yes, Yours. Running page 48. That is their objection before the learned trial court. We have stated that I am a destitute lady and I was subjected to harassment, and so I need the maintenance amount. How he has dealt with the same. Paragraph number 10. That the petitioner, may I permit it to be known that the petitioner is not only an arrogant lady, but is also a character of termagant in nature and always in the habit of living high-profile attitude with superior complexity. Though she came from a lower middle-class family, owing to her character, she never used to take part in any duties of the in-laws' house. And he has submitted that I have come from a lower middle-class family. I should be that downtrodden. I should not be maintaining the same standard. Thereafter, my lord. In paragraph number 11, he contradicts his own stand. He says that paragraph number 13, he says that I have having higher qualification and I am not destitute lady as has been portrayed in the application. Thereafter, in paragraph number 14, next page 49.
14 is higher qualification.
Yes. 14 is tara thik ulta ta.
You can use the bigger one.
Yes, your
because if you go for the smaller one, you will use this paragraph. So use the bigger one. Yes, Mr. Mishra. So after that indictment from the apex court, I cannot pass that order.
But this is a different case.
This is absolutely similar.
I am not trying for speedy discharge. What happened, Milad?
Just wait. Let this happen. I will take up the passport. Yes.
Yes. In para 14, he says first.
You have no difficulty in waiting, na? Or you want to go to another court?
Taken up some other.
No. It has to be disposed of. These matters cannot be kept pending.
I'm prepared.
Yes.
Para 10, he says that I come from a lower middle class family.
You are saying she has
landlord's daughter.
Yes. Master in social work. Yes.
And for 14, he says that I am a daughter of the landlord. I have landed properties. My father has landed properties. So I am not entitled to any maintenance.
Yes.
Thereafter, your lordship, I am coming to the impute judgment. Basing on what ground this judgment was passed and where the London Family Court misconstrued me. It is admitted fact
page
that
21.
Page 21 এটা ମୁଁ ଖାଲି ଏଇଟା ଦେଖେଇଦେବି 16 inner page 16 ସେଥିରେ it was established the London Trial Court also realized that I am having no source of income. That is mentioned in page 80 inner page 61.
Paragraph ଟା କେତେ judgment ର paragraph ଟା କୋ page mark match କରୁନି.
Oh acha inner page 80 your lords sorry running page 80 7th line from the top. Page number 18.
ଆପଣ who order ଟା
impugn judgment.
No by C.
Again, impugn judgment ଟା. Paragraph page number 80. Last.
तो 28/7/25 ଆପଣ କୋड କହୁଛୁ. It starts at running page 21.
Nice, ସେଇଟା ନୁହଁ. What is that?
ଆପଣ RPFF 264. Achha, sorry, I have opened the other page. Okay. Digital has this problem. If you don't realize actually physically what is happening. Impugn judgment starts at 65.
Yes. ସେଇଟା ମୁଁ page number 18 running page 80.
Paragraph?
Paragraph ଟା ତ previous page ରେ ଅଛି ବଡ paragraph ଟା 7th line from the top.
ଠିକ ଅଛି page 80. Page 80 internal page ଆପଣ କହୁଛନ୍ତି 16 right.
7th line from the top. Start is although there is no concrete proof. 1 2 3 4 5 6 sorry 6th line from the top.
Yes.
Although there is no concrete proof to show the income of the petitioner from our employment and freelancing YouTuber, but the records manifest that the petitioner has received her interim maintenance to the tune of rupees 13,89,000 as on 16/7/2025. The petitioner is facing sponsor. So, my lord, thereafter, I will permit you to take your lordship to page number 82.
So that is not disputed that you have received 14 lakhs, around 14 lakhs.
No, that is admitted. 13 lakhs some odd amount I have received from as interim maintenance. The London Family Court deemed as if it is my income.
So that
the London Family Judge deemed it as if it is my income.
Kindly just please further.
Malas.
कोटी कहले आपन इनकम बोली
Aye.
13,29,000 आज 16,725
As on 16,725.
yes
As on 16,725. The petitioner is facing subtle hardship without any permanent income and being legally wedded wife of the OP is entitled to maintenance. That is in my favor. The bold plea of the OP denying the affirmation and allegation does not come to his rescue. The argument of the learned counsel by placing reliance on the ratios of the Honorable Apex Court that the petitioner has filed the case after an inordinate delay were not entitled to maintenance and specifically argued that the petitioner has substantial source of income and did not need to support the respondent for the maintenance from the respondent. She was sufficiently able and failed to agitate the maintenance claim since long. The evidence laid by the OP means husband, to substantiate that the petitioner left his home without any just reason and cause does not convince the mind of the court. The evidence of the petitioner that she was suffering from ailments and was incurring a huge expenses for medical treatment is not authenticated by the support of any medical prescription to establish the ongoing health status of her treatment. As such, there is no proof to affirm about the poor health of the petitioner. The parties are living in separation since 31/10/2011. The evidence on record prima facie established that the petitioner has left the OP in lurch of evading her responsibility and marital obligations. However, it is also manifest that the OP has not taken any step for reconciliation and has made any effort to resume the cohabitation with her. Both the parties are prima facie exuding degree of cruelty against each other. The OP has failed to establish any ongoing, consistent, permanent source of income of the petitioner from the documents exhibited as Exhibit B and C to establish the income of the petitioner. The argument of the OP that he had a dependent mother does not curtail his liability to maintain his wife. The petitioner has laid evidence to prove that the mother of the OP was a pensioner and has an independent source of income. The OP has failed to answer and demolish the evidence about his assertion that he was a dependent mother. Furthermore, the assertion that the OP that he had dependent nephew to support his legitimately does not disclaim the entitlement of the petitioner for maintenance. It is apposite to place herein that the strict proof of cruelty does not form the mandate disallowing maintenance. Hence, in my considered opinion, the petitioner is deprived from the company of the OP and being legally wedded wife to be maintained by the OP. The petitioner is entitled to maintenance from the OP. In paragraph number 11, the learned trial court family judge says, the Honorable Supreme Court in the case of Kalyan De Chaudhary versus Rita De Chaudhary, such and such in criminal appeal number such and such, placing reliance on Dr. Kulbhushan Kumar versus Rajkumari and another, reported in 1973 SEC 129. He has laid down that the wife is entitled to 25% of the net salary of the husband towards the maintenance. The same has been held in our Honorable High Court in Matta 95 of 2015 in Srimati Ankita Mahapatra versus Arabinda Mahapatra. Taking into consideration the guidelines, the petitioner wife should be entitled to 1/4 of the income salary of the OP to the tune of rupees 66,005 rupees. That is 16,501. The judgment relied upon by the learned advocate for the OP of the Honorable Supreme Court of India in Rajnesh versus Neha, it deals about the adjustment of maintenance, and in case two or more proceedings against the husband, the petitioner on record has received a sum of rupees 13,89,000 towards her interim maintenance. Hence, the award of interim maintenance of 13,89,000 be adjusted towards the final monthly award of 66,005 rupees divided by 4 is equal to 16,501 towards the monthly maintenance. On the basis of discussions and the conclusive findings, taking into consideration the capacity of OP to make the payment and reasonable needs of the petitioner, an award of sum rupees 16,501 as monthly maintenance to the petitioner will meet the ends of justice. Hence, ordered. 16,501 rupees.
So that you are challenging the quantum, basically.
Yes, yes. I am challenging the quantum.
So actually, I could not understand. In fact, you have not understood. Could not understand the paragraph just above para 12. Because 25% is understood that it is 25% of 66,500. Kindly now take the order or read the order.
Mallards.
In the result, the application for maintenance, page 83.
In the result, the application for maintenance filed by the petitioner against OP5 under section 125 of CRPC is allowed on contest in favor of the petitioner and against the OP. The OP is directed to pay a sum of rupees 16,501 per month to the petitioner for the maintenance of the petitioner from the date of her application, that is from 23/12/2020. The current amount of maintenance with the arrear maintenance which is payable to the petitioner by the OP in 10 equal installments on or before the 10th of each succeeding month. The interim maintenance awarded and paid by the OP to the petitioner be adjusted from the total arrears amount. On the failure of payment, the petitioner is at liberty to realize and recover the maintenance award, through the process of the court. On peculiar circumstances, there is no order of litigation costs.
No, since the final amount, I think that is correct. If you have received the amount from 16 lakh, just start calculating, and you have a paper.
Yes, Lord.
16,501 from
23/12/22.
item 19.
19.
ତାଙ୍କର 23/12/2020 up to 23/12 ହେଲେ 23/4/2025 ତକ 12/2025 60 months. Then 4 months ହେଲା 64 months. So 64 ଆପଣଙ୍କର ଡେଟ୍ ଅଫ୍ ଆୱାର୍ଡ କେବେ ହେଲା?
Date of award
July 20.
is
28/7/25.
28/7/25.
So 28/7/25 ପର୍ଯ୍ୟନ୍ତ ଆପଣ ଯାହା ପାଇଛନ୍ତି, so
That will be adjusted.
that will be adjusted. That is fair enough.
My challenge is the quantum. That to 61,000 to 66
ସେଟା ତ ଆପଣ hearing over.
hearing over.
Of course ସେ ବି ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି, ଆପଣ ଏନହାନ୍ସମେଣ୍ଟ ଚାହୁଛନ୍ତି,
Yes.
ସେ ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି ଆମାଉଣ୍ଟ ଟା whatever. But ଆପଣ ଯୋଉଟା କହୁଛନ୍ତି ଯେ ସେ ମୁଁ ବସ to be fair, I mean to be fair, in fact I could not understand that paragraph.
Yes, ସେଟା ବି confusing.
ଆପଣ ଆଉଥରେ ପଢୁନାହାନ୍ତି, the judgment delayed happen by the
This is
ସେଟା ତ proceeding କଥା ସେ କହିଲେ, but he has not applied that.
yes.
If suppose in domestic violence in section 24
Well,
or that adoption and maintenance 28 whether suppose any other order is passed and amount is paid, that has to be calculated.
that is to be calculated.
But
and
here
adjust-
nobody's case is that, your case is not that you are receiving, rather their case is not that you are receiving any other amount. But 16,500 if you calculate for till the date or till today even,
That is around 10 lakhs, man.
ଆପଣଙ୍କର 64 64 months से कितने होचे multiply करें,
Right, in fact,
or I'll do that.
calculated for 66 months also. It
Ah.
was coming to 10,89,000.
So you have received the 1389.
1389. Interestingly, that the income the husband has sold that 66,000.
So that is a merit.
Yes,
Of course.
but that
You are
amount.
challenging, the point is well taken, that you are challenging the quantum.
My lords.
Obviously, or else why you will come to the court?
Yes, he's getting more than 1.5 lakhs, but he has showed in the asset and liability that 66,000. Only 1 month's pay slip he has given. I have annexed that in annexure 9.
So
that
it
requires hearing. my lords.
this has come for orders for why? Orders
Yes.
second.
Because it was listed for some other date and they have preponed it. That
First
is why.
RPM 264.
You should notice an admission age. Admission
Notice on admission. So
admit है ही नहीं.
हाँ.
अच्छा. So Ms. Ratha, let both the revisions be admitted.
Lordship, that's what I was actually saying, that let it be admitted so that it can be heard some other day.
Yes.
Well, in the the second matter, I have not received any copy.
Actually, what you are arguing, that's a valid point. You examine the case law on this.
My lord.
Now, Mr. Mohanty has read it. Purposefully, I did not ask him to read para 21 because 21 was that only. That what would be the income, whether, because the language used is involuntary deduction, like taxation
Yes.
and other things. Voluntary deduction will not be. But anyway, that is a matter of argument.
My lord. That is what I was actually going to argue.
After this 16,500 is not being paid to you. That is your
Yes,
case.
your lordship, that is my case. That is not, that is my case. And since when he stopped paying, before that judgment, Your Lordship.
Your Lordship, because she has
7 months. Let me clarify.
Okay. I mean, just make it very simple, straight arithmetic.
My lords.
That would be better. Instead of going when the date order was passed, when it was paid, total amount due till date, 66 months. You can check it with Mr. Mahanti. Kindly show the calculation.
66 into 1650.
Straight away. Upon the mobile. Good that you are hiding it in the file. Good. So I was thinking that how he's doing it like this.
Yeah, before the matter only I had calculated.
Yes. His screen rate calculator. Anyway, no, leave it there.
It is
calculation.
10 lakh 89 years. He is showing that in calculator.
Now, unless the quantum is increased by the court,
my lord,
there is as such.
That
for a interim for now, so that 13 lakhs will carry till which date?
Very
so now you decide, so now you do the next job, Mr. Mahanti. 13 lakh
89
13 lakh 89 को से divide कर दियो तो से amount quantum of maintenance. That would help.
Indeed.
ଆପଣ ତ ଟାବଲେଟ ରେ କରୁ
ଆଜ୍ଞା ଇମ୍ପ୍ୟୁନ୍ ଜଜମେଣ୍ଟ ମୁଁ ଖାଲି ଗୋଟେ କହି ଦଉଛି ଇମ୍ପ୍ୟୁନ୍ ଜଜମେଣ୍ଟଟା ହେଇଛି 28/7/2025 ରୁ ସେ କିନ୍ତୁ ପଇସା ଦବା ବନ୍ଦ କରିଛନ୍ତି ତା 7 ମାସ ଆଗରୁ
what you are saying is correct, but the problem is that you have to arrive at a figure. So if you arrive at a figure, the figure comes to 10 lakhs. You have received 13 lakhs. So you have to be patient with the proceeding. Or if you agree, I mean, Ms. Ratha.
Lordships, agree for
without prejudice to rights and contention, you continue paying 16 that amount, not the
Lordships, we have misunderstood on that point.
No, you will never be misunderstood because it will be direction of the court. Asking for agreement is in this sense.
It can be subject to final outcome of the.
Yes. No, but Mr. Corda, not the higher amount.
No, Your Lordships, what we are trying to say is this, that she has an additional amount of 3 lakhs something with herself right now, Your Lordships. So she cannot be said that she's without money.
But Ms. Ratha, if you read the paragraphs, though, I mean, if you calculate it, I mean, kindly again read the operative paragraph. Mr. Corda can read it. Or Mr. Mahanti. It says something else. Operative portion खाली से ordering portion पढ़ो.
In the result, the application for maintenance filed by the petitioner against the OP under section 125 of CRPC is allowed on contest in her favor, in the favor of the petitioner and against the OP. The OP is directed to pay a sum of rupees.
Slowly पढ़ो. 16,501 per month. It is not Subha amount.
That is.
That I did not mark.
The OP is directed.
But the addition is not Subha. Addition comes to 13 actually.
13.
At least 16,500 ठीक हो. Per month to the maintenance petitioner from the date of her application from 23/20.
The
current amount of maintenance with the arrear maintenance which is payable to the petitioner by the OP.
In 10 equal monthly installments.
I mean, what does it mean?
If anything is pending, that it seems my
court has recorded.
Court has recorded.
Of course, the court has not calculated like we are calculating now. That's the problem. When you do not calculate.
May I just say, please before Your Lordships is, let us exchange our pleadings. Let this come after vacation. On the first week itself, we will address and finish the matter.
The problem is that this month, the husband is retiring, my lord.
Yes, Your Lordship, husband is retiring. That does not mean that he'll be.
He works as
executive engineer. 2 years back, he was executive engineer in Rural Department.
Also, Your
I mean, how retirement will impact? I could not follow you.
Well, he will stop paying the monthly maintenance amount because he has retired. He might say that, and since
this is apprehension.
Well, 2 times NBW was issued. 1 time Hon'Ble High Court directed for attachment of salary. He has checkered history that not following the court's order. He can also kindly look at my date chat.
Mr. Parda, your anxiety is, I understand, or anxiety of the petitioner, I understand. But obviously, he cannot do that.
Your Lordship, he has an ailing mother, and he himself, Your Lordship, will see somebody is nearing retirement means he also must be having all kind of diseases, and his ailing mother, Your Lordship. And
I mean, no such Newtonian law.
I'm not saying that, Your Lordship.
Then please don't submit before the High Court because you are retiring at 62.
No, Your Lordship. No, not that, Your Lordship. No, Your Lordship. Even people at my age at 47 also have disease, Your Lordship. So I would not say that because of age. Your Lordship, what I mean to say is this, that I'm aware of the client's condition. She already has an additional amount. I think nothing will go wrong if Your Lordship takes this matter on the first week after the vacation. Because I can't fix on Your Lordship next week.
Most likely that learned court has not calculated. That is how the ordering portion is different.
Yes.
Ordering portion presumes that there is something area, as well as it is to be added to the current.
Yes.
But the court itself has recorded 13 lakhs.
Your Lordship, may also say that there was another round of litigation also where another coordinate bench took a little note that she was actually purposely delaying the ending of that matter and was taking that big amount, Your Lordship. So this conduct have been there at the side of the petitioner. So I'm just begging that it is not about my conduct at all.
There are 13 application pending.
No, Your Lordship. What? No, Your Lordship. My information is not so.
So in fact, when Mr. Parda was pressing it, I marked that there is no 13 application or 9 application is pending. If 13 is pending, then that question of whether it is prolonged or not prolonged, that would be a question.
None, at least my conduct has not been that bad, Your Lordship. As
that's a complete misconceived submission. If there is a 13 application, somebody is receiving interim maintenance, still 25 is past permanent alimony, then that can be a suggestive of conduct. But here, at least the parties have chosen not to, file any application.
We'll come back with all the instructions here. So first week of...
Whatever, so it be. They may be happy that way. We can't comment on that.
Yes, we can't comment and we can't even force them the other way. I'm very conscious of that.
I'll just confirm that there is no 13 application.
There is no 13 applications.
It's order of the kind. The learned counsel for the petitioner is heard at length. Appearance Mr. G.N. Parda for the petitioner. Ms. Pamirat, senior advocate, along with Mr. S. Mohanty for the opposite party. The petitioner's wife in the marriage is before this court challenging the order, the judgment dated 28.07.2025 passed by the learned judge Family Court Nayagada in CRL.M.P. number 187 of 2020. By the said judgment, the learned judge Family Court has favored the application under section 125 CRPC. 125 into bracket 1 into bracket small a of CRPC. Filed by the wife in the marriage, seeking monthly maintenance at the rate of rupees 70,000 per month and 20,000 towards litigation expenses. However, the amount of maintenance awarded is rupees 16,508. The further direction by the learned it is principally submitted by the learned counsel for the petitioner that the judgment suffers from incorrect appreciation of facts inasmuch as the amount awarded as maintenance has been arrived at by holding the monthly income of the petitioner to be rupees 66,000. 66,500.
66005.
66005.
Sorry, 66,500, which on the face of it is improbable when the petitioner was working 2 years back as a
executive engineer or
executive engineer in the department of
rural works.
in the department of rural works of the government of Odisha. Stop. Para. By order dated 10/11/2025, the coordinate bench had issued notice on admission and stay. Stop. Pursuant to the notice being sufficient, Mr. S. Mahanti, Learned Counsel, has entered appearance. Ms. Pami Ratha, senior advocate, has been engaged to argue the matter on behalf of the opposite party. The matter is admitted. No further notice be issued for admission hearing in view of the appearance of the opposite parties. It seems that the Learned Trial Court has relied on the exhibit of the pay slip of the petitioner to arrive at the figure.
1 month pay slip.
66,000. 66,506. Sure. The copy of this application shall be served on the Learned Additional Standing Counsel, who shall obtain the details of the pay received by the opposite party from the government, which will include the voluntary deductions made, the involuntary deductions such as tax and other things. The petitioner, the opposite party, if so advised, may file affidavit supporting the statement before the Learned Trial Court that he is in fact receiving rupees 66,605.
005. 66,005.
Whatever. 66 So the affidavit shall indicate the net pay, the gross pay, the voluntary, involuntary deductions such as tax and other things, the voluntary deductions, and the take-home salary. Stop. The matter shall be listed for admission in the week commencing. Quebec.
You lots fix it.
Yes, Mr. Barik. The matter shall be listed in the week commencing under the heading for admission in the on 29/6/2025. Then IA टा कोण आपण फाइल करछन 2020 आपण कोटा पाइछन 401/25 स्टे 2026 आपण सर्व करछन 200 IA 200 अच्छा
200 हां
yes sir. Is submitted by the Learned Counsel for the petitioner that the petitioner is the opposite party is retiring and his past conduct is such that for enforcement of the order of maintenance 2 times NBW was issued. There is a order of attachment
from this honorable court.
After which the order could be complied with.
I think, Your Lordship, there is a little mistake in that submission. There are other facts to it, actually. Those orders, I think, were recalled or something. It may not be a correct picture.
This puts the submissions of the Learned Counsel for the petitioner. She submits that there are other facts which needs to be mentioned before the court. Stop. Perusal of the order passed by the judgment and order passed by the Learned Judge Family Court indicates that the amount payable of the amount directed to be paid 16,501 is with effect from the date of application.
That is from DEC bar to
made by the petitioner, that is DEC bar 2020 till DEC 2 DEC 4 DEC 4 2025 DEC 26 ये तो 26 चलती नहीं DEC 4 2026 it comes to 64 months. if for 64 months the amount would be multiplied as observed by the learned Judge Family Court. The petitioner has already received rupees 13, 89, 000 as on 16/7/2025. ଆପଣ ଯୋଉ ରିଭର୍ସ डिविजन कले केते हला मिस्टर महतो?
So 64 months from it is 10 lakh 50.
13 टाको डिवाइड करो तो 13, 89, 000 divide by
16,501.
16,501.
84 months.
84 months. ठीक अछि. कौन देखिए? And if that is divided by the amount directed to be paid, 16,501, it comes to 84. Therefore, the amount due as on date would be as on date, no amount would be due. Considering the amount to be 16,501. Stop. सेटा confusion है ताको बड़े मोर भी confusion है. 84 टा काटी दियो. It would avoid that line. सेटा आपण तो लिखिले एति होची 13 लाख पाई चंदी आपण टोटल अमाउंट हैला 64 months पे केते होची
10 lakh 56.
1056 86. अपन सेटा मल्टीप्लाई कर लिखते into 64 कर देले छाड़ दियंतु. So as on date no amount would be due if the amount of maintenance is taken to be. Is further directed the petitioner shall file affidavit giving details of the retirement benefits he will receive upon attaining age of superannuation. The affidavit shall be filed by the next date upon serving copy thereof on the learned counsel for the petitioner. Paragraph solve. Date पे कहले हम तीस ऊपर जो अच्छे से रहेगा. Yes, the last को नहीं किए. RPFM 70/2026. Ms. Pamir Ratha, senior advocate, along with Mr. S. Mahanti for the petitioner. Opposite party blank. The application has been filed by the husband in the marriage, which is taken up along with the application RPFL 264/2025. Both the applications arise out of the judgment passed by the learned Judge Family Court, Noyagarh, dated offices at the Pochisi in CRL.M.P. number 187 of 2020. The application was favored. However, granting rupees 16,501 as monthly maintenance, though the prayer was to grant of rupees 70,000 monthly maintenance and rupees 20,000 towards litigation cost. In the connected RPFM, which was heard at length, the connected RPFM, which was heard at length after notices were issued earlier by order by the coordinate bench, dated 10/11/2025, has been acquitted. The para in the present application, the husband in the marriage, the petitioner husband in the marriage challenges the award of maintenance. Upon a quantum, you are denying maintenance.
Denying the maintenance.
Challenge the grant of yes, Mr. Ratha, your the young counsel is correct. You are denying the maintenance.
Yes, Your Lordship. He himself has drafted it.
Only. challenges the judgment and denies his liability to pay maintenance. Now, issue notice. Admit issue notice. Admit issue notice.
The delay is there, my lord.
Delay na conduct.
Delay.
the maintenance for जो लिखले नहीं challenges by denying maintenance. ऊपर IA लिखी थी IA has been fined seeking condonation of delay of reported delay of like कितने
Delay in value 105 days.
105 days.
105 days.
In view of the fact that the connected RPFM has already been admitted, the connected RPFM was taken up, notices were issued by order dated and admitted by today's order. The delay in the interest of justice and fair play, the delay in filing of the present RPFM is condoned. Consideration of this court has gone through the IA supported by affidavit indicating the explaining the delay in filing the application. The grounds shown are found to be sufficient and reasonable to condone the delay. The grounds stated for this, not shown, grounds stated. The IA is favored and disposed of. देखिए RPFM admit issue notice. Mr. G.N. Polda, Allied Counsel, submits that he has G.N. Polda, who is appearing in the connected application, submits that he has instructions to appear in the present application for the opposite party. Duly executed Okalatnama shall be filed within
3 working days.
Within 5 working days. Upon filing of the Okalatnama, name of the Learned Counsel appearing for the opposite party shall be reflected in the cause list as well as the case brief. The copy of the RPFM, IA copy अच्छी about extra copy.
IA kitchen data का कितने सर्व कर दो both the copies.
That dispose of it, सर्व को करिए.
Just for record will.
ऊपर लिख दूँ तो IA copy has been served कर दिया. Copy of the revision application shall be served on the Learned Counsel for the opposite party within 3 working days.
3 days.
Yes. Revision application along with all connected papers. 3 working days. Yes. Both the applications shall be listed in the week commencing 29/6/2024.
If I may suggest, time may be fixed or 2 p.m. or 3 p.m. so that
you have to shift to Delhi. You have to become an outstation counsel. So that you can make a prayer that since I am coming from Delhi, so my matter may be fixed. You take advice of your senior. Yes.
Madam, that thing was fixed at 3 p.m. There, madam, it is to be deferred, but your lordship send it for mediation.
16.
That was fixed to 3 p.m.
If you are not in a hurry, I'll call serially. He will call serially. Just give me a moment.
Get deferred.
Okay, no problem.
Because the cancellation is going on.
Yes. You suggested date?
But it may be in July because 18 तारीख को तांकर अच्छी.
केबे 18?
यही 18 को अच्छी.
18/5.
And that will be further progress. So
July हेले आपण रखंतु केते 13 जुलाई ना 20 जुलाई.
भाऊजी तोड़ आसी जाई जीवा उची
13 जुलाई.
दीटा सिटिंग हे गलानी. This will be the third sitting.
13/7.
But shall I pray one thing?
Yes, please.
May I take permission, madam?
Yes, please.
Item 21 is need to be press notices. Notice has been there is a noting. Notice could not be made sufficient because of
sir. आपण ये रे present correct address टा discover करो.
कोई साल नहीं है. कोई की memo टा लिख के रखी.
चल दियो तो फाइल कर दे. How much time you will file? कितने दिन रे फाइल करी requisites?
Time on day?
3 working days sir.
Obligers.
ଆପଣ ଟିକେ ଡାକନ୍ତୁ ଇଏ ପାଶ ସାର୍ ଡାକନ୍ତୁ।
File the memo before the.
ସରି ଶୁଭିଲାନି କଣ କହିଲେ?
This memo I will file a present current address also.
ସେଟା ରିକ୍ୱିଜିଟ୍ସ ହବ ଏଟା କୋର୍ଟରେ କଣ ହବ କି?
Yes, I will file there.
ରେଜିଷ୍ଟ୍ରିରେ ଫାଇଲ କଲେ ସେଟା
Yes, yes. Obligers.
That is my understanding. Requisites the court file हुए नहीं. Register कर देंगे.
Yes.
Yes, Mr.
Well, I'm not praying to this should be disposed of on priority basis. That I'm not praying. Fact is like this. They filed a petition for divorce. Husband has filed a petition for section 13. Counter was filed. And it was posted for framing of issues. At that time, the wife has filed stated that the matter is pending before the Hon'Ble High Court, matter 177 of 2023, which arises out of a petition rejecting the ordinary rule 13 petition, or section 9 petition was filed by the husband that was expired order against that is pending. No stay order that was not admitted, no stay order was granted. It was sent to conciliation. Because of that, charges not been framed. Framing of charge has been stalled. That is the sole procedure. I am not claiming priority bill. That you will also cancel.
Sir, framing of charge कले वाले issues
issue frame. I'm sorry. Issue frame.
Yes.
Issue frame पे आगे 23/8/25 रे. आगे.
तो नपड़ी की बुझी पड़ची ताले. अपन चार्ज कले वो बुझी गली.
I'm sorry. Extremely sorry.
No, but that
because of
so अपन तो पूरा direct तार conflicting ये कले. अपन जो दी सेटा now since now you have read that पूरा गला सेटा.
No, that is
allowed अपन देखते ना वो.
allowed देखले sir priority. I am not claiming priority.
The Supreme Court says that how this court cannot direct.
I am not also not praying for early disposal. That also I am not praying now.
Then what prayer is?
You may say only that the issue may be framed, issue may be settled, and matter may proceed. Because the matter is pending before this Hon'Ble Court and no stay order has been granted, it was not admitted also. Notice was also not issued. Only limitation matter notice was issued and it was condoned. Matter referred to the mediation. Because of that is stalled. That is my grievance. I am not.
42 students, sir. The situation at the grassroots level is better known to the judges of the courts concerned.
Yes, Miller. I have gone through Miller. I have gone through. I am not claiming priority Miller.
So say now then kindly answer this query.
Miller.
Have you taken any steps for framing of issues?
Yes, Miller, that has been done because it is. That's why I invite your lordship.
Now, if it is referred for conciliation.
No, conciliation.
Awaiting conciliation. How the court will proceed?
Section 9 report has been given.
ठीक हो.
Hello,
Section 9 हो कि 13 हो conciliation को refer हैला.
Section 9 रहेगा expiry order है.
Expiry order हैला पर सिस्टर challenge के refer हैला.
Matter is pending before the Hon'Ble Court.
Court will proceed. So I will only say that that if a application is moved making any prayer, the same shall be considered in accordance with law. I will not give any specific direction whether he will for records, whether he will frame issues, whether he will now start cross-examination, whether he will start examination with chief. That I will not.
No. That I am not also praying below. Only because of pendency of 177, matter 177, that is not that is stalled. That is the order below.
So you have to approach the matter court. If you are saying that matter court has, let us assume. But kindly assume that the proceeding in the matter court before the division bench before High Court has interdicted the suit there.
Notice has been issued.
Sir, how can I pass that order?
Notice has been
on your you are yourself saying that I don't that is a division bench. So you can approach that court. Obviously, if the pendency of matter has somehow interdicted the suit there, then matter court you have to make the prayer, not this.
So what I pray, my instruction is that the conciliation has failed. Report has been given.
Matter in a
matter conciliation has failed. Report has been given.
Actually, you should have moved the matter court. Matter court re apan move karitile. Court could have made some observation.
So
because what you are saying is I understood. Because that because of pendency of the matter, nothing is happening. Conciliation has failed. Section 9 has been
and
allowed.
also the section 9 petition has become in view of filing of this section 13 petition.
Whatever.
So
that prayer should have made before the matter go.
Yeah, Lordship is correct. So what I pray, Miller, so let it taken up some other date, Miller.
No.
Miller, in the meantime, I will move.
Sir, rather, if you move the matter court,
I will move the matter court.
So that I'll direct. I'll observe. In fact, I cannot direct, I'll observe. I cannot direct whether you will move the matter court or not. So because this kind of order cannot be passed by this court in view of the Supreme Court.
No.
Now you have.
I have gone through. I agree with you, Lordship.
No, Mr. Mishra, now you have said that the conciliation is by the direction of the division bench. How the single bench will take it up?
No. Priority claim kar dikhali.
Not priority, sir. Matter court re jodi conciliation report failure aschi and you want that the trial court should proceed. That prayer is to be made by the direction to be by the matter court, not the single bench.
Your Lordship. And also one judgment I want to say.
That would be fair.
My lord.
There is no judgment that when the...
No. Regarding this, my lord, Honorable Justice Deepak Mishra and Justice B. Gopal Gowda Miller, there is a decision reported in AR 2014 Supreme Court Miller, where in a 125 case Miller, their Lordship has held because how this case should be, matrimonial cases should be...
Sir, I rely on that decision. Rely on those decisions. And in fact, this Samyama Farooq is by the Honorable Justice Deepak Mishra. I understand, but obviously they have not said that whenever a
Lordship is correct, I should move the...
Yes. MATA conciliation you are saying that the matter is not proceeding.
You also may observe that.
The writ application has been filed with the following prayer. The parties to the present application, the petitioner in the present application is the husband in the marriage.
Husband is
the party is the wife in the marriage.
Husband is the petitioner.
It is submitted by the learned counsel for the petitioner that MATA number. Matter number
Matter number 177 of 2023.
MATA 177 of 2023 is pending. Ki file kale matter
Wife file karchandi.
By the opposite party wife in the marriage, challenging the ex parte judgment passed by the learned judge family court.
By the opposite party number 1 Miller.
Family court.
Family court.
OPL.
They are
by the learned judge family court.
Family Navarampur Miller.
Navarampur. In CP number?
In CP number. In CP number 9 of 2022.
9 of 20222. Stop. The said CP was filed by the husband in the marriage under Section 9 of the Hindu Marriage Act, seeking restitution of conjugal rights. The CP was favored ex parte against the wife, hence the matter. Stop. It is submitted that though the petitioner has in the writ application has approached this court for the learned
family court Jaipur.
For the learned family court Jaipur to proceed in the petition CP number
50 of 2014.
50 of 2014, which is pending for the
2024 cards.
Sorry. 50 50 of 2024. Which has been filed by the husband in the marriage under Section 13 of the Hindu Marriage Act, seeking dissolution of marriage and decree of divorce. But a 54-55 ବର୍ଷ ଲୋକରେ ଲଢେଇ କରୁଛନ୍ତି
ଆଜ୍ଞା
ବୁଝଉନାହାନ୍ତି ଆଜ୍ଞା 55 ବର୍ଷରେ ଆପଣଙ୍କର କମ ସେ କମ ମ୍ୟାରେଜ ର ହେଇଥିବ 20 ବର୍ଷ 25 ବର୍ଷ
ଦିଟା ଛୁଆ ବି ଅଛନ୍ତି ଆଜ୍ଞା ହେଇପାରିଲାନି ଆଜ୍ଞା ଦିଥର ହେଲାଣି ଆଗରୁ ତ ଜୟପୁର ଥର ହେଇଥିଲା ଏଇଠି ଥର ହେଲା ଆଜ୍ଞା
yes dissolution of marriage and decree of divorce. It is submitted by the counsel for the petitioner that during pendency of the matter before the division bench, which is still pending, the matter was referred for conciliation. And as per his instructions, conciliation has failed.
Report has been
And report has been received.
submitted.
Mediation, the conciliation is mediation.
Mediation, I'm sorry, mediation. High
Conciliation
Court.
is mediation. Mediation. The mediation has failed. It is submitted that the petitioner reserving his right to move the division bench for which the matter is pending will not press the present application. Accordingly, the application is disposed of. Yes, next please. Yes, Mr. Jafarullah, 14.
Matter item 14.
RPFM have filed an interim application, but the case is notice was issued.
Maintenance.
Maintenance at a time, my lord, the filed an interim for area petition has been filed, claiming 7 years. My lord,
Decree ta dekhiye order
decree judgment achi judgment.
What is the amount of decree?
My lord, judgment is
4,500.
4,500 ତାଙ୍କୁ 1,500 ଆଉ ତିନିଟା ପିଲା ପାଇଁ 1,000 ସେଥିରୁ ଗୋଟିଏ ପିଲା ଆମ ସାଙ୍ଗରେ
ପଢିଲେ ନ ପଢିଲେ ସେ ହବ। ଆପଣ ଯୋଉ ଅର୍ଡର ଟା ଦେଖନ୍ତୁ, your name madam? ଆପଣଙ୍କ ନାଁ madam?
Your Lordship, I am appearing on behalf of Mr. Jana. I am only requested for the urgent matter. Your Lordship. I don't have any instruction.
No problem. ଆପଣ ନାଁ ଟା କୁହନ୍ତୁ।
Vidisa sir.
Miss Vidisa Sheikh Jafarullah for the petitioner. Miss, you are writing B or V?
B.
Yes. B. Vidisa Sahoo on behalf of Udit Ranjan Jena for the opposite party. Order ta page 16 देखले Mr. Jafarullah?
हाँ, page 16 रे
4,500.
paragraph 9
16.
para 9 टा
केते देबे?
para 9 टा से देखंतु।
नहीं आपण केते देबे para 9 केते बोझ para 9 देइछन केते टंका आपण देइछन केते देबे केते?
तो
10 वर्ष हे गेल सर।
ना पिला वर्तमान मेजर हे गेलेनी।
नहीं सेटा आगे पिला मेजर हेले मु तो एग्जीक्यूटिव कोर्ट तो करि परिबे
ना एग्जीक्यूटिव कोर्ट
आपनकर कोर्ट रे जहा फैक्ट्स थिला
आज्ञा
पिला आपण स्टे हेथिला कि धरतो गोटे हमर पावर थांता बड हवाटा हम स्टे कर देले तो से दैट इज नॉट ए that would be illegal order. I pass that order that since the because if that was the plea before the trial court has not taken note of that. Then it's a different thing.
ସେତେବେଳେ ବର୍ତ୍ତମାନ trial court pass now they have filed an execution petition claiming maintenance of 7 years. That is
10 वर्ष होची ना 7 years.
आज्ञा से एट ए टाइम समस्त पिला मो पाखरे अछि
120 मास रे 4,500
4,500 पिला मो पाखरे अछि परा स्टार्टिंग
सुनो आपण सेटा से प्लीटा सेठी नेबे यू आर गोइंग बिहाइंड द डिक्री मु फाइनली आज हियरिंग कर परिबिनी आपण जदी स्टे चाहछोनी पैसा देबे इट इज योर चॉइस और जो मेरिटरी आर्गुमेंट करछन यू आर आर्गुइंग अगेंस्ट योरसेल्फ
हां नहीं मेरिट
सो आपण सो नाउ आई विल आस्क यू आपण कोठी ट्रायल कोर्ट स्टैंड नैथिले जे पिला आपण पाखरे रहउची तार वॉइस ऑफ मेजर से स्टैंडर्ड देखेबे पॉसिबली आई कैन इंटरफियर
नोटिस इशू नोटिस समरे भी हेतिला गोटे पिला मो पाखरे एनी ये लॉर्डशिप एट द नाउ
एप्लीकेशन करंतु टू एग्जीक्यूटिव कोर्ट रे इंस्ट्रक्शन नियंतु
सर बतान सम अमाउंट आई कैन
सम माने एसयूएम ना एसयूएम
SOME.
No, you tell SUM.
SOME.
Na SUM कुहंतु केते. What is the sum?
I can at best बर्तन मु देई पारिम सर.
Bargain करंतु नि?
Bargain.
You know, I am really somehow I am getting really आपनकर प्रॉब्लम होची दैट आपण रिवीजन रे नुवा केस आर्ग्यू करिवे. आपण जदी I know to what extent you can argue. आपण जदी से पॉइंट थाना आपण स्टेट में कहि थाते जे एविडेंस अछि से अछि. छुआ तो स्टे हेगी ना छुआ बड़ला पर्यंत आपनकर जेतिक ड्यू अछि आपण देबे
हां पिला बड़ हे गेले ना पिला ओपी नंबर 2 नाउ ही मेजर ही इज वर्किंग
से आपण दबो
से दबा का से तो बर्तन तार नो से ताको पई
2000 सुनो तो 2016 रे दिस इज जजमेंट केबे हैला
जजमेंट हला 2016 जजमेंट डेटेड हां 10/5/2016
वर्तमान आपनकर 10 वर्ष रे स्टे हेइथिले भी पिलाकर केते वर्ष हो
ପିଲାଙ୍କ ତ
ସେତେବେଳେ 8 ବର୍ଷ ହେଇଥିଲେ ବି ବର୍ତ୍ତମାନ 18
ଆଜ୍ଞା,
ଶୁଣ,
ବଡ ପିଲା
ଆପଣଙ୍କର
13
ମୋ କେସ୍
ବଡ ପୁଅ 13 ବର୍ଷ, ବର୍ତ୍ତମାନ ସେ 28 ବର୍ଷ ହେଲା।
ଗଲା 13 ବର୍ଷ ତଳେ ତାକୁ ହେଇଥିଲା 3 ବର୍ଷ 10 ବର୍ଷ ତଳେ।
ନା ନା 13 ବର୍ଷ ସେତେବେଳେ 2016 ରେ 13 ବର୍ଷ ଥିଲା। ବଡ
ଠିକ ଅଛି, ଆପଣ ତାକୁ ଡିଲିଟ କରିଥାନ୍ତେ।
ସେଇଟା ଥିଲେ ସେତେବେଳେ
ସେତେବେଳେ ଅବରାରକୁ ହେଇଥିଲା 13 ଆଉ ଚାର୍ଜକୁ ହେଇଥିଲା 7।
ଟୁଇନ୍ ଯେ ଅଛନ୍ତି, ଟୁଇନ୍ ଜଣେ 2 ଜଣ 7 ଅଛନ୍ତି। ସେ 2 ଜଣ
ଆପଣଙ୍କ ଆଜ୍ଞା ଗୋଟେ ମ୍ୟାଟର ଫେରେ 6,000 ଟଙ୍କା 4,500 ଟଙ୍କା ଆପଣ କଣ ହିସାବ କରୁଛନ୍ତି?
4,500 ନା ବର୍ତ୍ତମାନ ପିଲା
ଆପଣ କେତେ ଟଙ୍କା 4,500 ଆପଣ ଟୋଟାଲ ଡ୍ୟୁଜ ହଉଛି କେତେ ଟଙ୍କା ଆପଣ କିଛି ପଇସା ଦେଇନାହାନ୍ତି?
ଥରେ 22,000 24,000 ଡିପୋଜିଟ୍ କରିଛି। ଆଉ ଏକ୍ଜିକ୍ୟୁସନ ଏଇ ଏକ୍ଜିକ୍ୟୁସନରେ ଟୋଟାଲ ଏବେ ଆସିଛି ଏକ୍ଜିକ୍ୟୁସନ ନୋଟିସଟା ଟୋଟାଲ ଦେ ଡିମାଣ୍ଡିଂ ଏଣ୍ଟାର
executing court cannot go behind the decree.
ହଁ ବିହାଇଣ୍ଡ ଡିଗ୍ରୀ ବର୍ତ୍ତମାନ ପିଲା ମେଜର ହେଇକି ବର୍ତ୍ତମାନ ଏଟ୍ ଏ ଟାଇମ୍ ସମସ୍ତେ ଯୋଉମାନେ only mother has filed an application.
That is irrelevant. I have to reject that. ଆପଣ ଯଦି ସେଟା କହିବେ I reject it.
ଆଜ୍ଞା
ଆପଣଙ୍କ 7
ବର୍ତ୍ତମାନ ସାର୍
ଆପଣ ଯିଏ 7 ସେ ତାକୁ ହେଲା 17
7ରେ ଯେ 17
ଆପଣ you are chopping up the branch where you are sitting. ଆପଣ 5 ଯଦି ଆପଣ 1,500 ଟଙ୍କା ହିସାବ କରିବେ ଜଣକା ନା କେତେ ଟଙ୍କା ପଡୁଛି? 4 ଜଣକୁ ହେଲେ ହଉଛି 1,100 ଟଙ୍କା। 1,100 ଟଙ୍କାରେ ଆପଣଙ୍କର ଯୋଉ 5 ଯୋଉ ଯାହାକୁ 23 ବର୍ଷ ବର୍ତ୍ତମାନ ହେଇଛି ସେ ତ 18 ବର୍ଷ ଯାଏ ପାଇବ। ସେଠିକି ଛାଡି ଦିଅ 5 ବର୍ଷ
18 ବର୍ଷ। ହଁ ସେ 18 ବର୍ଷ
6,000 ଟଙ୍କା ଛାଡି ଦିଅ।
ସାର୍ ବର୍ତ୍ତମାନ ଏଟ୍ ଏ ଟାଇମ୍ ସାର୍ ପୁରା
ଆଜ୍ଞା ଆପଣଙ୍କର your point is completely accepted that Abrar will not get after 18 years.
Yes.
ଛାଡି ଦିଅ ପଇସା ଦିଅନ୍ତୁ
ସାର୍
ଆଉ କଣ ଆଉ ହବନି। 4 ଲକ୍ଷ ଆପଣଙ୍କର 4,80,000 ଡ୍ୟୁ ହଉଛି।
4,80,000 ଗୋଟେ କରିବା କଥା ସେ ଏଟ୍ ଏ ଟାଇମ୍
ଗୋଟେ ହବନି।
ସିଙ୍ଗଲ
125 ରେ ସେ କଣ ଏଟା ମନି ସୁଟ୍ 125 ରେ
ଏଟ୍ ଏ ଟାଇମ୍
akin to a money decree
ଏକା ସାଙ୍ଗରେ ଏକ୍ଜିକ୍ୟୁସନ ନ କରିକି
ଆପଣ ଦେଇନାହାନ୍ତି ବୋଲି ଆଜ୍ଞା। ଆପଣ 16 ବର୍ଷରେ ଆପଣ କହୁଛନ୍ତି ଆଜି ଆପଣ ଯୋଉ ଦୟା କରୁଛନ୍ତି 16 ବର୍ଷରେ 10 ବର୍ଷ ଦେଇନାହାନ୍ତି ସେଥିପାଇଁ କୋର୍ଟର ଅସୁବିଧା ହେଇଗଲା। Sir, it is you have remained in default in 2016. ଆପଣ ଡିସ୍ଟ୍ରକ୍ସନ ନିୟୁ କେସ୍ ଆର୍ଗୁମେଣ୍ଟ ହବନି କିଛି ଲାଭ ନାହିଁ କରି
ବର୍ତ୍ତମାନ ୱାରେଣ୍ଟି ଆଇ କ୍ୟାନ୍ ଡିପୋଜିଟ୍ ସମ୍
ନହେଲେ ଆପଣଙ୍କୁ ସେ ଆସିନଥାନ୍ତେ ଆପଣ ଏଠିକି ଆସିନଥାନ୍ତେ। ଆପଣ cannot be helpless and helpless.
The amount of maintenance ରହୁଛି ଜାଣିପାରୁଥିବେ ଯେ the financial capacity at a time ରେ ଦବାର ପୋଜିସନ ନାହିଁ।
କିଛି ନୁହଁ for a day I think it is difficult. 1,000 ଟଙ୍କାରେ ଗୋଟେ ଲୋକ ବର୍ତ୍ତମାନ ଯେ ସିଚୁଏସନ ହେଲାଣି
ଦେଇଥିଲେ ଏଟ୍ ଏ ଟାଇମ୍ ବର୍ତ୍ତମାନ
ଯାହା ବି at a time ଆପଣ ସେଟା at a time don't make it, so have to reject that. ଆପଣ ଯଦି କହିବେ I'll accept because you have remained defaulted for 10 years. How can you say at a time? ଆପଣ default କାହିଁ କରୁଥିଲେ at a time ରହିଛି ନା। Sir, your default you cannot take advantage of your default. ଆପଣ instruction ନିଅନ୍ତୁ। Let us not spend time already
some amount I will deposit your lordship till vacation your lordship କରନ୍ତୁ।
ଆପଣ ଆଗ ଡିପୋଜିଟ୍ କରିବେ ଆସିବେ ଆଜି ଡିପୋଜିଟ୍ କରିବେ ଯଦି ମୁଁ 6ଟା ବେଳେ ମ୍ୟାଟର ନେବି till 10 at least 10 I am available. ଆଜି ଏବେ ଡିପୋଜିଟ୍ କରୁନାହାନ୍ତି
next week ରେ I will obtain instruction how much I will deposit.
ତ ପ୍ରୋବ୍ଲେମ କଣ ହୁଏ କହିଲେ ତାପରେ it will be a fishing expedition. ନା ସିଏ ଡିପୋଜିଟ୍ କରିବ ନା ଆପଣ ତା କୋର୍ଟରେ କିଛି କହିପାରିବେ so it goes on the saga will continue.
No, that is
very difficult. You see he is such a stubborn person se चारिटा माने 4 souls have to survive. He has not given 4,000 rupees for 10 years and now he is saying that at a time I cannot give. As if he is doing charity by not depositing. सीधे 4,000 ଟଙ୍କା ଦେଇଥାନ୍ତା କିଛି ଦେଇଥାନ୍ତା
ସେତେବେଳେ ଦେଇଥିଲେ ବର୍ତ୍ତମାନ
କୋର୍ଟର ଗୋଟେ ସିମ୍ପାଥି ଆସିଥାନ୍ତା ଯେ ଗୋଟେ ଲୋକଟା 10 ବର୍ଷ ହେଲା 3 ବର୍ଷର ଛୁଆ ଦିଟା ଗୋଟେ the lady is about 10 was 32 years she has to fend for herself.
Situation has changed.
ସେ ପିଲା ବର୍ତ୍ତମାନ ସେ ପୁଅ ତ ପାଠ ପଢି ପାରି ନଥିବ
ଚାକିରି କରୁଛି
Abrar could not have read because that ITI କରିକି କଣ ସେ କରୁଥିବ
ଗୋଟେ ପିଲା ବାଚି ମେଡିକାଲ କଲେଜରେ ଚାକିରି କରୁଛି
what they will do
ନା ଚାକିରି କରୁଛନ୍ତି
twins single mother 3ଟା ଛୁଆ single mother how they would have survived. ଆପଣ କିଛି ଦେଇଥିଲେ would have done some sympathy. Have you married again?
No, yes, I have married.
That was the icing on the cake. I could guess it. In fact, I was not telling you because.
So that
So,
on
sir,
merit, that
so-
on merit.
so actually, the court is very lenient. It should have issued a distress warrant. Court is lenient with you. 10 ବର୍ଷ ପରେ ସେ ଆପଣଙ୍କୁ କହୁଛନ୍ତି ଆଜ୍ଞା ଦଉନାହାନ୍ତି ଆପଣ ସେଠି କହୁଛନ୍ତି ମୋ ଭାଇ at a time ହେଇଗଲା ମୁଁ ଦେଇପାରୁନି. Sir, you are having your happy married life. The poor souls, they are struggling.
Fact remains that so many things are behind that that I cannot.
ଆପଣ behind କୁ ଯାଆନ୍ତୁନି. If we go behind, then that will be you will be behind bar. So in another bench of this court always issues arrest and detention, and that is mandated by Supreme Court. In matrimonial matter, Supreme Court has said this: issue police notice, arrest and detention. Otherwise, if you see the concern in Rajneesh, 7 ବର୍ଷ. Rajneesh versus Neha, the opening paragraph, 7 years have passed for a implementation of a maintenance order. And it is not in lakhs. ये तो छाड़ो 4,000 कर रहा है.
ଏବେ କରିଲେ ନା ଏବେ
से जेबे भी कले. से yesterday that matter was argued also. This execution न होले हमें कहीं दबु. That is your argument.
that is my argument.
ଆପଣ instruction ନିଅ ତ deposit କରିବେ ଯଦି 4 ଲାख ଟଙ୍କା ତାହେଲେ stay ନେବେ.
I will obtain instruction now.
4 lakhs.
Pardon?
4 lakhs. 4 lakhs. 4 lakh ଟଙ୍କା 4 lakh 80 4 lakh ଟଙ୍କା executing court ଦେବେ. Or it will be a gross violation of the fundamental right of four souls.
4 souls no, all are now they are.
6,000 ଟଙ୍କା ଛାଡି ଦେବେ. ଆପଣ 80,000 ଟଙ୍କା ଛଡା ହେଲେ ନା ଆପଣଙ୍କର ମାନେ ଯୋଉ 13 ବର୍ଷର 5 ବର୍ଷର 5 ବର୍ଷ ହେଲା 60 ମାସ 60 ମାସ 1,000 ଟଙ୍କା କେତେ ହଉଛି ଆପଣ 80,000 ଟଙ୍କା ଛଡା ହେଇଗଲା.
ପିଲା ବର୍ତ୍ତମାନ I will obtain instruction.
Instruction ନିଅନ୍ତୁନି. Sum SUM.
Sum.
Obviously. Deposit the sum, get some order. Next sum is SOM is order. So you have done well to keep quiet and having patience, spending your time. Because you said that I do not have any instruction, I do not know anything about the case. Yes.
I'm submitting the copy. I'm submitting the copy of the IA.
So verification. The petitioner husband is before this court challenging the judgment dated 10/5/2016 passed by the learned judge family court Khurda in criminal petition number 22 of 2016. The matter was presented before this court on 16/7/2016. Notices were issued on 22/7/2016. On 31/8/2016, none appeared for the petitioner. The coordinate bench, the registered judicial noted that the notices to OP3 was returned answered and fresh steps were directed to be taken. Fresh steps for issuance of notice were directed to be taken. Thereafter, the matter was listed on 7/3/2017. On 11/2/2023. Made of 5/23. Of 12/23. And has been adjourned. Has either been adjourned or the petitioner has repeatedly remained absent. After the matter is kept pending for 10 years, and the IA has been filed in the year 2026. After when the judgment is put to execution by the opposite parties before the learned, by the petitioners before the learned judge family court, who are the wife of the opposite party, who and minor children, one son aged about 13 years and 2 sons aged about 7 years when the application was filed. In view of the judgment rendered by the Honorable Apex Court in Rajneesh versus Neha, the amount directed to be paid as maintenance is akin to a money decree. To sustain the challenge, the petitioner has to secure the amount. Stop. On being asked, the learned counsel for the petitioner submits that, as per his instruction, the petitioner remains in default for the last 10 years. The amount due comes to around rupees 4,80,000. For entertaining the application, the revision application, the petitioner has to secure the amount of rupees 4 lakhs, if so advised, by depositing the same before the executing court. The petitioner has adjournment. The learned counsel shall obtain instruction. List for specific dates out in 18 week रखिबे
Again.
List for orders in the week commencing 18/5. Yes, next.
Item 16.
Mr. Samir, Mr. Senior Counsel, along with Mr. J. Pradhan, Mr. Raut, I just forgot his name.
I am on behalf of Mr. Kara, Eskar.
Subhendu Kar. Along with Mr. J. Pradhan for the petitioner.
Sai Shubham.
Mr. Sai Shubham on behalf of A.R. Das for the opposite party. It is informed by the learned senior counsel for the petitioner as well as the learned counsel for the opposite party that there has been progress in the mediation between the parties to arrive at amicable settlement acceptable to both. The next date of mediation is 18/5/2026. Stop. Awaiting further report, further interim report, only report of mediation. The matter shall be listed in the week commencing 13/7/2026. Make your efforts. Try to settle it. Yes, next please.
17. 17.
Non appears for the petitioner. Though the matter is called twice over. Non appears for the opposite party. Non is also present for the opposite party. You also think you see it. To grant further opportunity, list in the week commencing, list for orders in the week commencing.
29/6.
18, Mr. Mahanti, your matter, fast over.
18.
In this case,
Prem Kumar Mahanti, additional standing counsel.
the petitioner challenges the order dated 2012-2000 of the LAR, in which I filed a petition for condonation of delay. Condonation of delay of 150 days, my lord, in filing of this appeal, my lord.
Okay.
Already the Honorable Supreme Court. Supreme Court in SLP number 215 last page of the order. On para 96. IA is
205,
IA number 206.
Dispensing ta kono sir? Dispensing file korchen ta?
Dispensing already allowed, my lord. My order dated.
ଆଗରୁ notice ହେଇନି ଏତେ 2 ବର୍ଷ ହେଇଗଲାଣି.
Would be accepted 22/10/2020. 18.
ସେ SLP ଟା allow ହେଇଗଲା ନା?
Yes.
Delay ଟା ଯୋଉଟା.
Condonation of delay has not been allowed.
IA 206 of 2024.
Let notice go.
The The IA has been filed by the appellates under Section 5 of the Limitation Act, seeking condonation of reported delay of 120 days unto 120 days in filing the appeal. The Learned Additional Standing Counsel submits that when the appeal was filed, the civil appeal before the Honorable Supreme Court was pending regarding condonation of delay in filing LAA. The civil appeal has been disposed of. So, what is the judgment? This is embraced. Disposed of by the judgment dated 9/2/2026. Paragraph 97 of the judgment is reproduced here. It is submitted by the Learned Counsel, the Learned Additional Standing Counsel, that the delay in filing is to be condoned in view of the law laid down by the Honorable Apex Court in SV Global Mills Supra. Issue notice along with this order. Requisites for issuance of notice. Respondent ki jana? So the respondents jane.
One, Tikalal.
Tika no se, Tikelal. MPO कहले हो. The requisites for issuance of notice to the respondent shall be filed within a period of 7 working days. Notice for issuance of requisites for issuance of notice by speed post with registration and proof of delivery. Returnable date be fixed to 7 July, 7/7/2026. The matter shall be listed for orders in the week commencing 13/7/2026.
I filed another IA 209.
कौन है ला? तापर इसे डाल अर्जुन होत लाइते जो इतने थोड़ा लिस्ट है इसी कौन ऑर्डर कोई किसी है
No order.
जो सुप्रीम कोर्ट पे अवेट करती है.
Madam, ordering Supreme Court. Another IA has been filed for stay of the impugned order, madam.
कितने ना आईटा कितने?
IA number 219 of 2000.
आईए नंबर 219 of 2024. Art Learned Additional Standing Counsel for the appellants. He submits that unless the operation of the impugned award is stayed, judgment is stayed. Judgment award both incident.
Award.
Impugned award is stayed. The appellant shall suffer irreparable loss and injury. So, issue notice as above, accept one set of process fee as well as postal requisites. Along with the upon issue notice in the IA and the appeal. And the appeal. Issue notice as above. Accept one set of process fee and postal requisites. The returnable date and the next date of listing shall be as directed above. In the interim, it is directed that
The file one execution case, my lord. The
judgment dated 28/12/2023 passed by the Learned Presiding Officer, capital LAR&R Authority, Northern Division, Commerce Hon'Ble in LA case number 260 of 2022 shall remain stayed until further orders. List in the week commencing 13/7. Liberty to mention. Yes.
Item 20.
Mr. Lalitendu Bhuya for the petitioner, Mr. Prafula Chandra Acharya for the opposite party. It is submitted by the learned counsel for the opposite party that he has filed an objection. Copy of which is served on the learned counsel for the petitioner. The matter shall be listed for orders in the week commencing 6-7-20-26. Yes, call.
Item 21.
Mr. Prabhas Chandra Jena for the petitioner. The learned counsel for the petitioner refers to the office note, which indicates that notice issued to the sole opposite party has been returned undelivered with postal endorsement. Court it is submitted that the petitioner has been able to discover the present correct address and notice may be issued afresh in the present correct address. Stop. Prayer is allowed. Petitioner shall take notice in the present correct address. Requisites shall be filed within 3 working days. Unutilized copies and requisites shall be utilized. Upon filing of the requisites, the registry shall proceed to issue notice in the matter. List after SR, liberty to mention. Yes, next.
22.
Mr. S.K. Samantray for the petitioner. Opposite party pai?
Opposite party.
Sir?
BK Sender. That's it.
BK Sender for the opposite party. Samantray mentioned for adjournment. You agree for that or you have been objection?
Copy.
Copy dinandi. The podele. ये फोन करी कह दे मिस्टर सामंतरे कॉपी नोचंदी अपन पाखे फोन नंबर अछि कोर्ट मास्टर को कह दे से वकलत नंबर देखि कि कह दे the learned counsel for the petitioner seeks for adjournment. The learned counsel for the opposite party अपन तो नोटिस परे पाई ना अपन
वकील नाम
ठीक है जो the office note indicates that due to filing of incomplete requisites for issuance of notice could not be issued. And in the meanwhile, the opposite parties have appeared. The opposite party has appeared, represented through Sri Deepak Kumar Ponda, Sri B.K. Senda, and learned associates. Appeared through learned counsel, Sri D.K. Ponda and B.K. Senda, and learned associates. Stop. Learned counsel for the opposite party submits that he may be provided with a copy of the application as well as other annexes. Application along with annexes. The learned counsel for the petitioner shall provide copy of the application and annexes within 3 working days. Is 23. Right? The matter shall be listed in the week commencing.
Yes,
sir. Shall be listed for everyone earlier.
Nice.
But shall be listed for orders in the week commencing 13.
23.
May I please allow?
For the petitioner. Yes, please.
So, this I for delay lordship 238 days. That's for my report.
What is the revision about?
Revision final order of the 125.
Yes.
They passed by the Lord Judge Family Court Judge 4 and awarding 15,000 in total, 10,000 to the mother and 5,000 to the child.
Yes.
The delay process with the counsel appearing in the trial court, he has not take part in the proceeding, not intimated to the order, and the in the
but unless upon kete deposit court with instruction achi 15,000
ଏବେ warrant ହେଲା ଯେତେବେଳେ execution ରେ he has been arrested and given 21,000 deposited and a release on bail loss.
जाजपुर तो पूरा रही जाउछ जाजपुर हैव सीन फॉर 85,000 से पूरा मासे रही गले तापरे वाइफ आउ दे पालेनी प्रॉपर्टी स्टेटमेंट से केस ड्रॉप हे
ये
दे आर बिकमिंग गेस्ट विद
as a respondent I am mentioning the stay
किसी दियो तम कोन तो देबे नोटिस इशू करिवे अपन इंस्ट्रक्शन दियो भल से अपन कथा सुनिबे अपन कोन तो जाय कोर्ट सुनु ना पैसा डिपॉजिट करो आपनकर ड्यू हल 15,000 माने आपनकर
एक्सपर्ट ऑर्डर लेबर पिलाटा माने 60,000 विदाउट एनी
4,000 देबे लेबर ग्राउंड ता नाही लेबर आपनकर समीमा परे समीमा फारूकी बा जस्टिस मिश्रा
the maintenance to the माने so far the merit of the case without considering any
13 और 9 तो चाइल्ड पे एप्लीकेबल नो
ना
ताले केमति आपण लेबर होत जाउ आपण तो पिला तो पुसियो पड़ियो
yes that is माने 15,000 जोटा करिसंती सेटा without asset liability without any proof of income that has been assessed by the court so again
the problem for the court cannot avoid its duty to adjudicate because आपण देखो कि नोटिस हेतिबो से अपियर कर नथिबे
नहीं अपियर करचंती
conveniently lawyer को blame कले
no
the court also cannot say anything
no last one record I am saying that appear करचंती WS फाइल करचंती again WS फाइल करचंती तापरे सेबान जते एविडेंस स्टार्ट करचंती आ ये
मेंटेनेंस रे फाइल करिवे
क्रॉस एग्जाम
लॉयर को देखा करिवेनी ताको फीस देबेनी से मेंटेनेंस फाइल करे 125
सेटा तो
I have seen
सेटा
this
भी तो again
when before just when
हमें भी
when I
हमें भी
started in
इसको
99
सुनांती again
when I started in 99 I went to Bokaro so there I went to the district court where I saw everyone is standing then it was I think it was in maybe divided it was Jharkhand
again
at least 4-5 persons audio ta band kare Tepe upon asking to deposit, authorized will not be sent.
no sir I pray lordship execution case 2,53,000 ऊपर करिसंती तो let me to deposit some amount notice टा जाओ तापर आसला
Deposit न कले मु करिवे
again
because
50%
then the problem is then it becomes like you have seen I think you were there
again
2016 मसिया केस 2026 रे आईए फाइल होची because court is not doing it purposefully court is overburdened आपण गोटे केस फाइल हला पड़ी रहला सेठी आपण स्टे से केस रे जे कोर्ट रे कहले आगे हमरो हाई कोर्ट रे पेंडिंग अछि डिवीजन पेंडिंग अछि से रहला सेंटे ता भितरे छुआ बड़ हो गेला बर्तन आपणकर भी छुआ पे अछि so I mean this is happening because of indirectly we are party to the whole thing in frustrating the maintenance awards what has been said in some Rajneesh is correct from one court to another court it takes 7 years time
delay notice टा जाओ
notice तुम करूनी ऑनर को आपण मु फेवर करछु
नहीं
पर्यंत कोनोसी मैटर रे मु डिले नोटिस करिन आज भी तो करिन काली भी करिन आपण इंस्ट्रक्शन नियंतु so how much you will deposit
the will 50,000 will deposit
1 lakh
मतलब तो पारियोनी से
नहीं से 1 lakh ऑर्डर नहले से दबनी
नहीं 50,000 लॉस में डायरेक्ट नोटिस शो से
टोटल अमाउंट ड्यू केते देखो त
2 लाख 2,53,000
21,524
एजुकेशन टा 2 लाख त पंच 21,5 रु मु कैलकुलेट भी करिछि टोटल 345 होछि
21/5 ରୁ 21/5/26 ହେଲା
23 months ହଉଛି as on date
24 ମାସ ନା
23 ମାସ
ହଁ ଏଇଟା ପରା 21 ହେଇନି 23 ମାସ
23 ମାସ।
ରାଇଟ୍ ରାଇଟ୍ 23 ମାସ
23 ମାସ ହଉଛି 15,000 ଲେଖାରେ 3,45,000
ହଁ ଦେଇଛନ୍ତି 20,000
21,000
ହଁ ତାହେଲେ ଲକ୍ଷେ ଟଙ୍କା ତ ଭେରି ରିଜନେବଲ୍ ଆଉ ଲକ୍ଷେ ଟଙ୍କା ଦେବା ପାଇଁ କୁହନ୍ତୁ ଆପଣ ଗୋଟେ କାମ ତ 2 ଲକ୍ଷ ଟଙ୍କା କୁହନ୍ତୁ ସେ ଲକ୍ଷ ଟଙ୍କା ଦେବେ ସେ କଣ ଦେଖୁଥିବେ ୟୁଟ୍ୟୁବରେ
ନାଇଁ ସିଏ
ଆପଣ ତ 2 ଲକ୍ଷ ଟଙ୍କା କୁହନ୍ତୁ
ଦେଖୁନାହାନ୍ତି
ଆରେ ଆପଣ ଯଦି ତାଙ୍କୁ କହିବେନି ଆଜ୍ଞା ସେ ଜମା ଶୁଣିବେନି ସେ ମିଷ୍ଟର ଜାଫରୁଲ୍ଲାଙ୍କ ଅବସ୍ଥା ହବ ପୁଅ ବଡ ହେଇଗଲାଣି ମେକାନିକ ହେଲା ଛୁଆ କୁଆଡେ ବୁଲୁଛି ଗୋଟେ କିଏ କାମ କରୁଛି So they are see the law is meant for that for those I mean
15,000 ଟଙ୍କା ଯୋଉ କରିଛନ୍ତି ସେଟା ବହୁତ ହାୟର ସାଇଡ ୱିଦାଉଟ୍ ଇନକମ୍ ହେଲା ତେଣୁ ଲର୍ସିପ
minimum wages because I have already seen some cases minimum wages it comes to around 4,000 5,000 ଟଙ୍କା
ମାଇଲ
5,000 ଟଙ୍କାରେ ଆପଣ କେତେ ହଉଛି
ତ ମଲା
ନା 34 ହେଲେ 5 15 ସିଧା ହେଲା 5 20 170
23 ମାସ
ଆଚ୍ଛା ମୁଁ 30 ଗୁଣି ଦେଲି ହଁ
1,15,000
ହଁ
1,15,000
ଲକ୍ଷେ ଟଙ୍କା ଠିକ ଅଛି
ଲର୍ସିପ ଡାଇରେକ୍ଟ
ହଁ ମୁଁ ଡାଇରେକ୍ଟ ଦେଲେ ଫେରେ ଆଉ ଅର୍ଡର ହେଇପାରିବନି ଆପଣ ନା ଇନଷ୍ଟ୍ରକ୍ସନ ନେବେ ଡିପୋଜିଟ୍ କରିବେ ନା ମୁଁ ଡାଇରେକ୍ଟ କରିଦେବି ଲକ୍ଷେ ଟଙ୍କା ଡିପୋଜିଟ୍ କରିବେ ବୋଲି
1,00,000 ଟଙ୍କା ଡିପୋଜିଟ୍ କରିକି ନୋଟିସ୍ କରିବା
ନୋଟିସ୍ ତାପରେ ଡିପୋଜିଟ୍ କଲା ପରେ ଠିକ ଅଛି The petitioner had ordered counsel for the petitioner.
ତ ମୁଁ ଇନଷ୍ଟ୍ରକ୍ସନ ଟା ନେଇ ଯାଉଛି
ବେଟର ଆଜ୍ଞା ତାପରେ ଆପଣ କଥା ଶୁଣିବେନି ସେ କେସ୍ ଗଲା
ଆସୁ ଗୋଟେ ୱିକ୍ ପରେ 18th
you
week
put your client to terms they will not cooperate with you
ମାଇଲ
yes ঠিক আছে the petitioner husband in the marriage is before this court challenging the judgment dated 24/7/25 passed in CRP number 119/2024 said judgment passed by the judgment dated by the Learned Judge Family Court Jajpur in criminal proceeding number 119/2024 The criminal proceeding was initiated by the wife in the marriage and the minor child represented to the mother guardian under section 125. You take your seat. I'll just take 2 minutes. Under section 125 of CRPC, seeking monthly maintenance for both of them. 125 bracket repealed and substituted by pari-materia provision contained in section 144 of PNSS. Before the Learned Family Court, it was stated that the marriage was solemnized on 19/2/2021 and the opposite party husband, as father, has neglected to maintain the wife and child stuff. The application was favored, directing payment of rupees 10,000 for the wife and 5,000 for the child. So the claim was 15,000 for the wife and 10,000 for the child. Apparently, the opposite party was set ex parte interception file is like expert in. Eta mu out of brief full dili.
Interception file is on contest.
Contest allow it. So next selection line cut it. It is submitted by the learned counsel for the petitioner that the opposite party could not it is submitted by the learned counsel for the petitioner that execution has been launched for enforcing the direction of payment of monthly maintenance. The learned counsel is apprised of the judgment of the Honorable Apex Court in Rajneesh versus Neha, wherein it is wherein the Honorable Apex Court have held that the maintenance awarded to wife and child is akin to money decree. The petitioner, in order to sustain the challenge, has to secure the same. The petitioner has adjournment. Learned counsel shall obtain instruction. The matter shall be listed for orders in the week commencing 18.
Yes.
Week commencing 18. Yes. Yes, please.
Page 27.
Your Lordship, I am on VC. Your Lordship, item 27, I am on VC.
Actually, 26. Continue adjourn petition. Date can be 27. Yes, madam.
Your Lordship, on behalf of my senior, due to the unavoidable medical emergency, Your Lordship, I humbly pray that this item may be kindly be taken up any day next week.
Here, Mr. Sudhakar Rao is appearing, senior counsel.
Yes, along with Saroj Kumar Padhi, my senior.
So Saroj Kumar Padhi, Miss Subhasri Pradhan on behalf of Saroj Kumar Padhi for the petitioner. Mr.
Your Lordship, there is the interim order.
Mr. Prabhu Prasanna Behra, additional standing counsel. For the opposite party, number 1, 2, 3. So, Jane Ponda, you are appearing here.
On behalf of Mr. Biswabihari.
Mr. Biswabihari Mahanti, along with Mr. Sorry, I forgot your name.
Gyanendra. Gyanendra Chaitanya.
Mr. Gyanendra, Mr. Gyanananda Ponda.
Gyanendra Chaitanya.
Mr. Yes, Mr. G. Chaitanya. You say G. Chaitanya, actually. That is how I am unable to repeat.
Sorry.
So Gyanendra Chaitanya, on behalf of, along with Mr. Biswabihari Mahanti for OP4. Adjournment is sought for on behalf of the learned counsel for the petitioner on personal grounds. On ground of personal difficulty, the matter shall be listed for orders in the week commencing. This is orders. That's what I say. That was it. The matter shall be listed for admission in the week commencing 20/7/2026. Interim order. Is Mr. Chaitanya any difficulty in continuing the interim order? Do you know the date of the interim order?
Yes, Your Lordship. From 19/4/2023 till continue.
19/4/23.
Yes, Your Lordship.
Interim order dated 19/4/2023 shall continue till the next date of hearing. So, Mahanti, interim order is seeking on medical health ground of the council.
My lord, health ground, I should not have objected.
So now you should also sit down and catch your breath.
My lord, only thing is,
so that Mr. Chaitanya will not play health ground.
My lord, only thing is the matter has virtually become infructuous. Your lordship may kindly see
What was the
No, you sit down.
order which is challenged?
I'll hear you.
And that
just after one two matters, I'll hear you. No problem.
That's an
About your rule, the madam. Don't leave the code. VC chhadi ki jaan to nahi. Just wait to hear your senior.
Yes, Your Lordship.
Passed over. That order is there already dictated, but just wait. What he is saying, just listen to him.
Yes, Your Lordship.
Tapare, call for
item 20.
You take your seat, Mr. Mahant. Just catch your breath. Back here for you. Mr. Sushanta Kumar Joshi for the petitioner, Mr. Bharat Bhushan Rautray for the opposite party. Adjournment is sought for on behalf of the learned counsel for the opposite party. Due to personal difficulty, the matter shall be listed for admission in the week commencing 6/7/2028. Yes, next. Order भूले गला 28 से लिखिए Registry has counted that the order dated inadvertent typographical mistake has crept into the order dated 9/5/2026. The serial number of the order shall be corrected as 7 instead of 6. Necessary correction be carried out. Yes. Next.
29.
29, my lord, I am on VC.
Ashok Kumar Behra, acha, put rate.
I am for the
28 rating order acha.
In first item, two petitions by
I am for the
two petitions by one is by wife and one is by husband.
Yes.
Husband is seeking transfer from Raurkela to Jajpur. Wife is seeking transfer from Jajpur to Raurkela. In last occasion, I had suggested for a middle person. That is Hon'Ble or Kotak.
That is the first case mail, the TRPCRL 18/25. That is infructuous mail. That case has already been disposed of by the learned family judge. Since that is infructuous.
ठीक अच्छी ताले सेना डिस्पोज ऑफ हेरन मिस्टर बेहरा दैट 402 टा आपनकर कोठी कोठी की
डिस्पोज ऑफ
और जाजपुर राउरकेला
सेटा 80 पेंडिंग टीआरपी सीआरएल रे स्टे थिला ता भीतर कोन हिची माय लर्नड फ्रेंड वाज saying that this matter has been disposed of.
नहीं 402 जाजपुर राउरकेला
नहीं है यार रेकॉर्ड
जाजपुर राउरकेला अपन जाजपुर राउरकेला तो व्हाट इज योर टू मिस्टर बेहरा
अनुगुल हेले भलो होता
जाजपुर जे अनुगुल रे केमती पहुंची
या तीनटा केस
जाजपुर पानी के की जिबे अनुगुल रे
नले कटक कर देले मिल पहुंची
ठीक हो जे आपण करो देटी कटक रे
आया तीनटा केस रे गले आ एक केस रे रहबे के तीनटा केस रे राउरकेला जाउछंती
तीनटा राउरकेला गलेनी
आया जाइछंती
सबले राउरकेला जाउछंती कहउछंती
498 केस रे जाउछन डीबी केस रे जाइछंती
आपनकर सब केस राउरकेला आगे तो अकाट्य जुक्ति आगे एदा काटी होबन
नले मते नले ये बीसी फैसिलिटी देले
नहीं सेटा तो आईसीटी टा सी भी अवेल करिवे आपण अवेल करिवे किंतु आपण मिस्टर नायक कहउछंती जे आपनकर सब केस राउरकेला रे एक केस काहे जाजपुर रे हबो is arguing in your favor.
हाँ जाजपुर
लॉर्डशिप जो क्रिमिनल प्रोसीडिंग ता
हाँ जदी जाजपुर रे सब केस ला
नहीं राउरकेला सब केस
अने मु तो जाजपुर रे रहउछ ना मु जाजपुर रे
आपनकर सब आपण जाजपुर रे सब केस राउरकेला जेतु होची तो एक केसटा काहे जाजपुर रे हबो सेटा से पचाउछनी तो तार तो कि आंसर नहीं एटा भी राउरकेला हवा कथा इज एज सिंपल एज दैट यस कौन कहउतले
सेटा एक्सपर्ट ऑर्डर रे हम आपके नो
एक्सपर्ट हो कि आपण सीसीटर पार्टी सो
इंजीनियर को जणे
ऑर्डर 9 रूल 13 से फाइल करिवे ना तो ट्रांसफर ही करिवे
से कहले तमे जाई सब बेले से कहले न जाई परिवार एटा एक्सपर्ट ही छै
हस्बैंड जाई पर ना योर वाइफ एस करियो ने वेरी इजियर टू
एटा काली उडे आई हैव डिस्पोज्ड ऑफ वन मैटर मिस्टर नायक तो सेटा भी हस्बैंड कोचंती सेटा भी राउरकेला कटक राउरकेला जाजपुर नो मु आई कटक आस परिबेनी तले वाइफ केमती आसीबे त सेटा भी गोटे क्वेश्चन you should argue I mean you are making open ended argument ଯଦି ଆପଣଙ୍କ difficulty ଅଛି ଯିବା
I
ପାଇଁ,
have difficult ହଉଛି କଣ ଗୋଟେ ଡେଲି ଲେବର ସେ ରାଉରକେଲା ଯାଇ ଆଟେଣ୍ଡ କରିବା ବି ସେ ଯାଇପାରୁନି ବୋଲି ସେ ସବୁ ମ୍ୟାଟର ସେଠି ଡିସ୍ପୋଜ ଅଫ୍ ହେଇଯାଉଛି ଏକ୍ସପାର୍ଟ ଦ୍ୟାଟ ଇଜ ଦ ହୋଲ ପ୍ରୋବ୍ଲେମ ଫିକ୍ସ ଗୋଟେ ମିଡିଲ ପର୍ସନ ହେଲେ ବି ହୁଅନ୍ତା
Coming to Cuttack is filing the case, number case, but he is not going to Raulkela. Intentionally, he is not going to Raulkela.
ଆଜି ଯାହା ବି କେସ୍ ଅଛି ହଜବେଣ୍ଡ ମାନେ ସବୁ ଡେଲି ଲେବର।
Yeah. He's a diploma engineer.
Had husband to be the daily laborer.
The diploma engineer.
Mr. Why this has happened, Mr. Behra, after he has engaged to become a daily laborer? He is a diploma engineer.
ଆଜ୍ଞା ନା ସେ ସବୁ ଭୁଲ କହୁଛନ୍ତି ମୁଁ କେବେ କୋର୍ଟ କୁ ଭୁଲ କହେ
ଠିକ ଅଛି ତାହେଲେ ସେ ଡିପ୍ଲୋମା ଇଞ୍ଜିନିୟର ସେ ଚଏସ୍ କଲେ ଆପଣଙ୍କର ସେ କାମ କରିବା ଯେ ନିଜେ କାମ କରୁଛନ୍ତି he should engage laborers to work for him. So if all the cases are at Raulkela, that's a good point, Mr. Se haruntu pache Raulkela re ho, so that apan high court re karibe sabuda ko apan, so that uniformly sabudire hari jibe, so that sabuda ka high court ko asibo.
VC facility dele
VC, of course that ICT is available, that paragraph will be there. VC naba pai, it has to be. The first year P serial 18-20-25. Mediation failure. Failure. Mr. Ashok Kumar Behra for the petitioner, along with you are Mr. Srutiranjan. Yes, Mr. J. Swine for the petitioner. Mr. Pavitra Kumar Nayak for the opposite party. The petitioner husband in the marriage is before this court. Seeking transfer of criminal proceeding number 109 of 2024 pending before the Learned Judge Family Court Raurkela to the Learned Court of Learned Judge Jajpur. Seeking transfer. Seeking transfer by filing application under section 447 of BNSS 2023. Stop. It is submitted by the learned counsel for the opposite party that states criminal proceeding number 109 of 2024 has been in the meanwhile disposed of by order dated
8/1/2026.
8/1/2026. Past record देवे रखिबा सेटा
Can I get a help from my friend to have a copy of that order?
I'll provide. Just now I'll provide.
Disposed of 8/26 by the Learned Judge Family Court Raurkela. He produces a photocopy of the said order which is taken on record. He shall serve a copy of the order on the learned counsel for the opposite party. It is submitted by the learned counsel for the opposite party that the judgment has been rendered ex parte. So, in any view of the matter, after the petition has been disposed of, the application under section 447 of BNSS for transfer of the said application would not survive, and accordingly the same is disposed of. अपन लिखिए TRPC 402 of 2024. Mr. Pavitra Kumar Nayak for the petitioner, Mr. Ashok Kumar Behra along with Mr. Jyotiranjan Swine for the opposite party. So जो ऊपर वाले भी लिखिए दे ऊपर ऑर्डर लिखिए by this court has referred the matter to for mediation which has failed as per the reports dated 12/8/2025. Appearance just opposite appearance. The wife in the marriage has filed the application for transfer under section 447 of the Bharatiya BNSS 2023 for transfer of civil proceeding number 368 of 2024, pending before the Learned Judge Family Court, Jashpur, to the Court of Learned Judge Family Court, Rourkela. The CP has been initiated by the husband in the marriage under section 13(1), 13 into bracket 1 into bracket 1 small I, Roman I dash A into bracket I dash B of the Hindu Marriage Act, seeking dissolution of marriage and decree of divorce between the parties. Dissolution of marriage solemnized on 29/11/2019. It is submitted by the Learned Counsel, supporting the prayer made in the application. It is submitted by the Learned Counsel for the petitioner that there are three cases between the parties.
Paragraph 6 that I mentioned.
Mentioned Portugal. Referring para 6 dekhi dega. 3 cases between the parties. GR case pura lekhi debe. So buda ko 6 para 6 re page 4 re achi, which is pending before the Learned Judge Family, which are pending before different courts at Rourkela.
Only gote disposable out of 3 or gote
Out of which the CRMP, it has been disposed of. High Court direction ଦେଇଥିଲେ ଆଗରୁ transfer ପାଇଁ କିଛି Rourkela
ନା କିଛି ଦେଇ
ସେଟା stay ହେଇଥିଲା ସେ ମ୍ୟାଟର ଟା stay ହେଇଥିଲା ହାଇକୋର୍ଟ stay କରିଥିଲେ ସେ କେମିତି ସେଠି dispose of କଲେ ତା in the meanwhile in both the transfer petitions mediation କୁ ଯାଇଥିଲା.
Petitioner submits that in view of the provisions contained in CPC section 9, so would a criminal or matrimonial case?
Matrimonials arising out of
the opposing the prayer for transfer, the Learned Counsel for the opposite party refers to section 17 of the Hindu Marriage Act, section 7 of the Family Courts Act, sections 9 and 24 of the Civil Procedure Code to submit that. In view of the clear statutory provision, the court at Jashpur has jurisdiction to entertain, and accordingly, the matter should continue to be tried at Jashpur. Stop. It is submitted by the Learned Counsel for the petitioner that the distance between Jashpur and Rourkela is substantial. That is about
nearly 500.
It is about 500 kilometers. The petitioner is already has been prosecuting 3 matters at Rourkela, out of which 1 has been disposed of, and 2 matters are still pending at Rourkela. She stays with her parents. She stays with her parents at Rourkela after her marriage has gone into wrong weather. So, accordingly, it is submitted that the prayer should be allowed. Prayer for transfer should be allowed. Having heard Learned Counsel for the parties in considered view of this court, though the contentions raised by the Learned Counsel for the opposite party are tenable, but taking a lenient view regarding the status of the wife, this court directs transfer of the CP number FT pending at one so-called Jashpur to the Learned Court at Rourkela, Learned Judge Family Court, Rourkela. Copy of this order shall be forwarded to the Learned Judge Family Court, Jashpur, as well as Learned Judge Family Court, Rourkela. It is submitted by the Learned Counsel for the opposite party that so ICT paragraph put nahi, the ICT paragraph pa pura likhe. So you also have the liberty to appeal through ICBC, but it has to be according to the rules and subject to availability of the facility. Yes. Yes, next.
27
Item.
अरे 27
Item.
और
Yes,
पासओवर
your lordship.
और पासओवर আছে বড় পাসওভার কইবে না আপনার হঠাৎ প্রসিডিউর করবেন কি
Lord,
Yes, yes.
can I draw your lordship's
Yes, please, yes.
attention to 19 of the PDS control order?
Yes.
Your lordship may kindly.
Appeal.
Yes. So it's an order which is appealable going by the clear language appended in the statute itself.
Yes.
So the writ petition on that ground is not maintainable. This is my preliminary objection which I have raised in my counter as well. But in my counter affidavit, I have clearly raised that point as well. That has gone uncontroverted till today.
সিতপেদলা দেহ খারাপ হয়ে গেল
My lord.
তো রিডিং ইওর কাউন্টার তান দেহ খারাপ হয়েছে তা
Besides your lordship may kindly see a person who
19 actually they are always raging. Mr. Lenka, Mr. Mahanti, Mr. Behra, Mr. Sethi, they always stand up and say 19. So that সিতপেদ আজি পাই দেহ খারাপ থাও
I am not there. Only thing
ଆପଣ ଶୁଣନ୍ତୁ ଦେହ ଖରାପ ବେଳେ ମନ ଖରାପ କରନ୍ତିନି ଆପଣ ଦେହ ଖରାପ ବେଳେ ତାଙ୍କ କେସଟା ଡିସମିସ୍
with your lordship's
ରେମେଡି ଗ୍ରାଉଣ୍ଡରେ କରିଦେବେ କେମିତି ହବ
with your lordship's permission,
no I'll record your submission.
One more sentence, my lord. The very same license on which the petitioner has been relying upon by placing it under Annexure 1 clearly says that under this control order of 2016, your lordship, kindly come to page 8, only first line.
Yes.
Subject to the provisions of Odisha PDS control order 2016.
Yes.
And that bears the provision of 19. And your lordship may kindly then come to one more page, that is page 10.
No, in fact, there are several writ applications. At least I have also disposed of that.
There is
19.
Judgment delivered by this honorable court also clearly says that the writ petition is not maintainable.
Yes, yes.
I'll take
and actually also I don't know whether they are skeptical. In 2 cases I have found the appellate authority has allowed the appeal. When the matter was kept pending and this court directed that you conduct an inquiry, they have given Mr. Behra has very clearly filed an affidavit. Very unique thing.
So he
says that there is no allegation.
In that event, let them file that appeal.
But see, senior asantu.
And besides, my lord, this writ petition has been filed after the period of subsistence of license is long since over. License was up to 31st March 2023 as per the Annexure 1 itself, which they places reliance upon.
Hospital is শুনথিবে তার অবস্থা কোন হবো? Take note of that. Yes.
Sorry, well. So, my lord, this is
19 টা কি আপন নেইଥିଲେ 27 টা কোন লিখଥିଲେ? তা পূর্বর লিখে দেবে personal difficulty আপনি ইনসার্ট করুন মিস্টার বিশ্ববিহারী মাহান্তি Lord Counsel submits that the order before this court is appellable. The order challenge before this court is appellable under section 9 or under order 19 of the OPDR control Odisha
PDS control order
PDS control order 2016.
Obliged.
He further submits that the appeal has been the writ application has been filed after the period for which the petitioner was engaged as a PDS dealer was over. Yes. তারপরে তাଙ୍କର prayer adjournment. Yes.
My lord, can I frame my lord? My lord, what has happened? Taking advantage of the interim order operating in this case, the POS machine supplied by the government that he is returning, he is not returning back.
Should I say he's favorite of Mr. Behra? The High Court has never directed you return the POS machine. Mr. Prabhu wants that you will have that. So what he will do?
So my lord, the entire system is going haywire.
POS. Actually, I think they would have tagged it to some other dealer.
They have tagged. That is what they have challenged. The order of challenge is the tagging. Why the tagging took place? And he returns it.
There I differ as a lawyer. I was discussing with Mr. Das that if it is not tagged, if it is allotted to another person, then there will be, suppose now the appeal is allowed or say it is allowed.
Yes.
Then if it is not tagged, you cannot get it back.
Yes, it has been tagged.
Tagging is a proper method.
Yes, the present order is a tagging order.
The other person who has been deprived of the dealership.
Yes.
So he
here such a contingency will not arise.
He can be again engaged.
Well, here another existing dealer has been tagged with this quota of this particular dealer. So there is no such contingency which will arise. Hon'Ble.
Yes, so POS machine को नहीं चाहिए तो काढून तुम Mr. Braham.
3 वर्ष हेगलाणी आगे से रखुचंदी फेरौना एवं all these
ସେ ତାଙ୍କର ଫେଭରାଇଟ କଣ କରାଯିବ?
Hon'Ble.
Yes.
ମାନେ
Date କେବେ କଲେ?
was counseling 40 sir.
20 7 week. Yes, next.
Hello, item 30.
Item
30,
30, my lord, I am on
one thing,
receipt mode,
आपको
my
जोड़ा
lord.
urgency नहीं, since we are already ahead of, I mean, really the time is over. So adverse order तो हमारा नहीं. पण कोई take up कोड़ा हवा पे चाहूँगे खाली mention करो.
Item 35,
Item
my lord.
30, my lord,
Lord,
I am on receipt mode, my lord.
This is the
Item
mediation.
30, my lord, item 30.
Page by page. Let us go serious. 30 रे कौन पहुँचेंगे madam?
30, my lord, opposite party had never appears, my lord. This is petition is filed under 447 of BNSS to transfer the CMC number 49 of 22 and 25 of 22. My lord, so far as CMC number 25 of 20.
Since you are there, you can't see the report of the learned assistant session
My
judge. I have
lord, this
to
case
look at.
may be taken up any other day, my lord, since I'm not feeling well today. I'll
No,
taken up
but
any.
I have already assured that I am not passing any order, adverse order, much less. So, just whoever is mentioning urgent matter, that I am looking at.
My lord, interim order is there. 10/9/2025 interim order was there, my lord.
There is a earlier order by this court directing the learned trial court to give a report. So, what is the report I am going through?
Interim order to be continued, my lord.
Yes. This is S. Das for the petitioner, opposite party, none. Pursuant to the order dated 12/11/2025 and the subsequent order dated 25/3/2026. The learned assistant session judge, my office letter dated 19/1/2026 has intimated the registry of this court that the order passed in the present TRPCR has been served on the opposite party. Parties on 24/11/2025 to the office of the court of the civil judge senior division -- assistant session judge into bracket women's court bracket closed comma Hon'Ble. So, however, no one is appearing for the opposite party despite sufficiency of notice. Stop. The learned counsel for the petitioner seeks extension of the interim order. Stop. The interim order dated
10/9/2025, my lord.
10/9/2025 is reiterated. Passed by the coordinate bench is reiterated. The CMC number 25/2022 pending before the learned assistant session judge into bracket women's court Hon'Ble shall be adjourned beyond. Shall be adjourned beyond 20/7/2026 upon a prayer being made for the said purpose to a date as should be convenient to the learned court in season of the matter. The matter shall be listed for admission in the week commencing 13/7/2026.
Obliged, my lord.
Yes.
My lord, item 39, my lord. 38, my lord.
31, 32 detach. Just. I'm going serially.
31, 32.
Just. 31 ଆପଣଙ୍କର?
My lord, 31, my lord.
ଆପଣଙ୍କର କେତେ ମ୍ୟାଡାମ?
33.
ଚलो 31 के ना ठीक ଅଛି ଡେଟ୍ କରିଦିଅ 31 yes please yes Mr. Pagal ତ ବିକ୍ରମ ବଢେ appear କଲେ ଓକିଲ ଆସିଗଲେ କେବେ କୁ ଆସିଲେ ହବ you suggested date after vacation okay 31 date କର সেটা অর্ডার কিছু হবে হ্যাঁ আগে পোস্টিং হয়ে গেল 32 মিস্টার দাস 32 your matter Mr. Das
32.
to Suryakanta Das
Yes, sir. Lord.
yes 32 ଆପଣ ଅଦର ସିଟ୍ ପାଇଁ ଆଫ୍ଟର ଭେକେସନ ଠିକ ଅଛି ଡେଟ୍ କରିଦିଅନ୍ତୁ ତ
Same order to continue.
ଏଥିରେ କ'ଣ ନା ଏଇଟା ରିଚ୍ କରିନି ଇଣ୍ଟରମିଡିଏଟ୍ ଆଡଜଷ୍ଟମେଣ୍ଟ ନା ଷ୍ଟେ ଅଛି
Stay ଅଛି.
ଷ୍ଟେ ରିମେନ୍ସ ଅନଟଚ୍ଡ Mr. Das Miss Bhagat
This is for enhancement of maintenance.
yes
The opposite party has not filed his assets and liabilities.
since the time is over court time is over you take a date because now order cannot be passed other side has to be heard and you have to be heard
My lord,
কিন্তু ଓକିଲ ଅଛନ୍ତି କି ନାହାନ୍ତି 33 ରେ other side ଆପଣ
no, 39.
anyone appearing for the opposite party so ଠିକ ଅଛି ଡେଟ୍ କରିଦିଅ
Full council 29/6.
29/6.
ହଁ ନା ଆପଣ 13/7 ଚାହୁଁଛନ୍ତି କେବେ ଚାହୁଁଛନ୍ତି
29/6.
29 ହଉଛି ଆପଣଙ୍କର ରିଓପନିଂ ୱିକ୍ ର ଫାର୍ଷ୍ଟ ୱିକ୍ ଟା ପର ୱିକ୍ 22 ରେ ଓପନିଂ 29 ତାର ନେକ୍ସଟ ୱିକ୍ 29/6 ୟେସ୍ ମିଷ୍ଟର ଚିଞ୍ଚାଣି
ରେଷ୍ଟୋରେସନ ମ୍ୟାଟର ଆପଣ ଲାଷ୍ଟ ଟାଇମ କହିଥିଲେ ଅର୍ଡର୍ସ ରେ ଆସୁ ବୋଲି ଆଜି
ଆଚ୍ଛା ଏଇଟାକୁ ଅର୍ଡର୍ସ ନେଇ ଆସନ୍ତୁ
ଏଇଟା ସାର୍ ନେକ୍ସଟ ୱିକରେ ଆସିପାରିବ ଖାଲି
ସେଥିରେ ଆପଣଙ୍କର ମିଷ୍ଟର ବେହେରା କୁଆଡେ ଗଲେ ସେ ତ ଆଜି
ବେହେରା
ତାଙ୍କ ନାଁ ବାହାରିନି
perhaps under the impression
ଏ ପ୍ରତାପ କୁମାର ବେହେରା ଅଛି ଅଛି
yes
ହଁ ଅଛି
ଆଚ୍ଛା
ସେ ଆପିୟର କରିଥିଲେ ଆଇ ରିମେମ୍ବର ଟୁ ଦ୍ୟାଟ ଇଜ ହାଉ ସର୍ଚିଂ
ନେକ୍ସଟ ୱିକ୍ କାଇଣ୍ଡଲି ଆଣନ୍ତୁ ଖାଲି
ଠିକ ଅଛି
ରେଷ୍ଟୋରେସନ
ଆପଣ ଯେବେ ଆସନ୍ତୁ ଅର୍ଡର୍ସ ତ ଆସିବ
ଆଜ୍ଞା
ଆଣନ୍ତୁ ଏଇଟା 34 ଅର୍ଡର୍ସ ଆଣନ୍ତୁ ଗୋଟେ କେବେ ହେଲା
ନେକ୍ସଟ ୱିକ୍
ନେକ୍ସଟ ୱିକ୍ ରେ ଆପଣଙ୍କର ଆକ୍ଚୁଆଲି ଦ୍ୟାଟ ଇଜ ଇସ୍ୟୁ ସେ ଯୋଉ ସିନ୍ସ ଆଇ ଏମ୍ ମନିଟରିଂ ହାଉ ମେନି ମ୍ୟାଟର୍ସ ଆର୍ ଲିଷ୍ଟେଡ
ଆଜ୍ଞା
next week shows already 115
କେବେ
because this is the issue because once we start sharing
you are
the operation
not
order
kind enough to list this matter
No, no.
in spite of
I mean
କେବେ
I have to list man I have to do the work we commencing utterance as to orders as yes 35
In this case, my lord, in this case, mediation report has come. Both parties have agreed to file the 30B of Hindu Marriage Act. And paramount alimony already fixed. Let's give this matter any other date next.
so after you obtain 13B I'll but the problem is that is to be passed by a division bench
13B ପାଇଁ ସେ medicine report
କହୁଛି କହିଲେ 13B ରେ ମୁଁ କହୁଛି ଆପଣଙ୍କର ଯୋଉ ଅମନପ୍ରୀତ କୌର what is that ତମର ହରମନପ୍ରୀତ actually ଆସିଯାଉଛି କ୍ରିକେଟର ନେମଟା ଆସିଯାଉଛି the court will not detain itself for the cooling off period that is a judgment but that order is to be passed in a by the division bench in because 13B appellate authority of course I don't know if I can pass that order
the mediation results that they will file withdraw the 13 application which is filed by the opposite party and another 13B fresh joint petition
13B ରେ ଆପଣଙ୍କର ଗୋଟେ 6 months mandate ଅଛି ନା
that is
Harbin ko not Harmanpreet Harbin Amandeep versus Harbin
but that is not bad that will be not
ଆପଣ ସେଟା ସାଇଟ୍ କରି ପାରିବେ ତ
ଆଜ୍ଞା ଆଜ୍ଞା
ଠିକ କର Mr. Rajesh Ranjan Sahoo for the petitioner 35 so Subodh Kumar Mahanti for the opposite party a paucity of time intervenes the matter is mentioned by the learned counsel for the parties stating that the mediation has resulted in amicable settlement acceptable to both the parties the parties have agreed to move the learned judge family court under section 13B 13 capital B of the Hindu Marriage Act seeking divorce on mutual consent that as per the terms of the mediation report and the agreement between the parties the amount to be paid by the husband to the wife in the marriage has also been has been mutually agreed stop accordingly the parties shall file the application on 13B court decide করছেন
the pending case is pending for the family judge Jaipur
not everything was settled except the jurisdiction the wife will reside in the Malkangiri jurisdiction and the husband residing in the Jaipur Milad now the question is in the mediation report everything was settled now there is
mediator cannot fix
yes no, now there is conflict
mediation cannot fix
yes that
yes
So there cannot be, because always jurisdiction is statutory.
Again.
Section 17 re habo, section 7 re habo.
Now, my lord,
So 7 or 17 re ଆପଣ ଦି ଜଣ କାଇଁ କହୁନାହାନ୍ତି?
no, my lord,
Don't leave it to the parties. ସେମାନେ କଣ ବୁଝି ପାରିବେ?
try colony. Now the problem is, my lord, they are not.
ଆପଣ ଏତେ ବାଟ ଆସିଲା ପରେ ଗୋଟେ ଛୋଟିଆ ଜିନିଷଟା.
ସେ ବୁଝା
Have you ever traveled to Jaipur and Malkanagiri? They are not that far also.
ସେଇଟା ଟିକେ ଯଦି ମାଲକାନଗିରିରେ ଫାଇଲ ହୁଅନ୍ତା it will be convenient for the petitioner.
ପେଣ୍ଡିଂ ଅଛି ଜୟପୁରରେ ସେଇଠି ହେଲେ 13B ଫାଇଲ କଲେ
ପ୍ରୋବ୍ଲେମ ଅଛି ଯେ ଆପଣଙ୍କର ଗୋଟେ 13 ତ ପେଣ୍ଡିଂ ଅଛି ଜୟପୁରରେ.
ଆଜ୍ଞା
ଆପଣ ମାଲକାନଗିରିରୁ ଜୟପୁର ବେଶୀ ବାଟ ନୁହଁ. ଆପଣ ସେପଟେ ଜାଣିଛନ୍ତି ନା ଜାଣିନାହାନ୍ତି?
ଆଜ୍ଞା
ଜାଣିଛନ୍ତି ନା?
100 କିଲୋମିଟର ମିଳର and this is
pending ଅଛି ଦିଟା
ସେ ଟିକେ ଯିବାକୁ ତମେ ସେଠି
ଆରେ ସେ ଆପଣଙ୍କର already you are getting everything man.
ଆଜ୍ଞା
You are ଆପଣ ଯୋଉ ତାକୁ destitute ସେ କରୁନାହାନ୍ତି, you are just dragging the proceeding. ଆପଣ ଯେତେବେଳେ he has agreed for everything, permanent alimony, the matter is settled, the parties are happy. ଏଇ ଜିନିଷଟା ପାଇଁ ଇଏ କରନ୍ତୁନି. So I directed Jaipur. ଆପଣ କୁହନ୍ତୁ କୋର୍ଟ କହିଲେ ଜୟପୁର ବୋଲି.
ସେଟା ଓପେନ ଥାଉ ସେ ଜୟପୁରରେ ଫାଇଲ କରନ୍ତୁ.
ଜଲ୍ଦି କରନ୍ତୁ.
ଆଜ୍ଞା ଆଜ୍ଞା.
The parties are directed to file the application under section 13B of the Hindu Marriage Act within a period of 2 weeks.
ଆଜ୍ଞା.
Within a period of 3 weeks. As agreed. The learned judge family court shall not detain itself for the statutory period to pass in view of the judgment rendered in Amardeep Singh versus Harvind Kaur. Citation they did. But it is expected that in view of the positive development, the parties shall achieve the objective of arriving at an amicable settlement. Yes. The matters shall be listed in the for orders in the week commencing 27-26.
There is a stay. Probably ସେ withdraw ହେଇପାରିବନି ନହେଲେ
ସେଟା ତ ମୁଁ କରିପାରିବିନି. ଆପଣ ଷ୍ଟେ ହେଇଥିବ MATA ରେ. ଏଇଠି ଷ୍ଟେ ହେଇଯାଇଛି.
ଆଜ୍ଞା TRPC ରେ ହେଇଛି.
କାଟିବା. 55. The interim order dated 26/8/2025 passed by the coordinate bench is vacated. The learned judge family court Jaipur shall proceed to dispose of city number 03 of 2025 upon filing of the application between by the parties under section 13(B) of the Hindu Marriage Act. Yes.
My lord, item 39, my lord.
My lord, item 38.
38, yes.
Yes, my lord, in this case, I am for the opposite.
Date niyantu, sir. Time is over. The date niyantu. The other
My lord, 39.
Next week, sir, afternoon is optional labor କିଛି ନାହିଁ, sir. As you have heard, 120.
Lord,
ଆପଣ ତ ପଢିଲା ବେଳକୁ ଯାହା ବି ସେଇ 5ଟା ବାଜିବ. ବୁଝିପାରୁଛନ୍ତି? And in some matters, we are getting stuck also. Though not required that much of hearing, we are hearing those matters for some quite long.
Your lordship's
After vacation na before vacation?
Before vacation.
और तो केबे 18/5 करो 18/5
item
37
18/5 भी 110 कर सले. Yes.
39, my lord.
39, yes, Mr. Sundar.
My lord, say challenging the order dated ये जो national लोक अदालत, my lord. Your lordship's part the order interim order till 11/5/26. Yesterday I was mentioning, my lord.
This matter. 39, Mr. Dityendu Sundar Rai for the petitioner. The paucity of time intervenes. The matter could not reach during the day's proceeding. It is submitted by the learned counsel for the petitioner. The matter is mentioned actually. The matter is mentioned by the learned counsel for the petitioner and it is submitted that the interim order dated 27/1/2026 should continue in order dated 9/2/2026
then my lord 23/26
first order କହିବେ ନା 9/2/2026 should continue during pendency of the present petition before this court. Accordingly, the said order dated 9/2/2026 is reiterated. The operation of the order oblique award dated 14/12/2024 passed in 4th National Lok Adalat देखी पूराटा लिखियो para 6 रे अछि 19/9 para 6 shall remain state till the next date of hearing. The matter shall be listed for admission in the week commencing 20/7/2026. Yes.
In item
37.
37 item.
37.
I am for the petitioner. Just
Yes.
now I have received the copy of objects and my counter affidavit filed by my
You take a
learned-
date.
Yes.
Because now hearing or don't expect that only this kind of urgent
only
yes 37 टा date करो तो केबे
before vacation can it
बिफोर वेकेशन किसी लाभ नहीं सर आपनकर 11/5 रे अछि 115 20 टा 18/5 रे 110 टा आ 18/5 टा एक्चुअली आपनकर ता मझिरे फंक्शन 12 रो सब थाए
again 20 परटू आउ
से पखाळ एवं अदर थिंग्स आर देयर अदर थिंग्स इज स्काई इज द लिमिट आपण आर्गुमेंट ही परिबन आर्गुमेंट ले सॉरी वन so it is better to
I have
avoid
already
those
filed
situations. Yes.
only question both are residing at Raigada. The transfer petition has been filed from Bhavani.
Level रे जदि करि परिबे you always free to mention at least in matrimonial matters.
CRLMC
I always entertain if you are successful. Today there are mentions. This item you have seen now, the item 35.
Arising out of this matter, one CRLMC is pending. In that matter, both of us are in a mediation proceeding. The city settled he jauchi, ebi city sorry jo.
Try to do that.
Agya.
Make an effort.
Eta in the meantime 10th.
I am not passing any order. It is simply adjourn. If you are achieving a mediation, be quick to mention before the court and get the order. Because that change of mind is a problem. What has happened in 35, they have achieved everything. Now they are thinking where to file the 13B. And that too in Jaipur and Malkanagiri. Both places are good. And in the 13 is pending at Jaipur. The same law will file. What is the what? And Jaipur is the senior bar, you can say. Parent bar. Jaipur is the parent there. This प्रकार problem हो अपन डेली कर. We take care of that.
That mediation is fixed to 10th of this month only. If it is settled, we'll make it.
Try to settle it. Yes. Thank you.
Shall I file it here?
You file it in the registry. Because this is a paperless format. If you file it here, it is not getting tagged. Yes.
Grateful.
Yes, please.